May please, Your Lordship. Your Lordship, I beg to mention item number 10, Your Lordship.
Just admission, criminal petition.
Criminal petition 24, drawn 5, Your Lordship. Your Lordship, here I have action to appear for respondent 2, 3, and 4, Your Lordship. If time be given to file my power as well as my affidavit is needed. 1 week's time be given, Your Lordship.
You are for the petitioner. Learned counsel appearing for respondent number 2, 3, and 4.
Your Lordship.
See,
Private
six time to file affidavit. Full stop. Prayer is allowed. List after 2 weeks or 1 week?
Lordship, 1 week.
List after 1 week.
Much.
Thank you.
Sorry for the indulgence, Lordship. I have a matter in court number 1.
No
so
problem.
if I mention it's a contempt, item number 7. We have complied with the court order, Lordship.
Okay.
So if I would like to place on court the payment that has pending salary.
Should we take up after some time?
Fine, Lordship.
You can do that matter and
Fine.
you can keep it in the file. You do that matter and come. Do it.
Please, Your Lordship. Lordship, I beg to mention hearing item number 15. 1-5, Lordship. On behalf of my colleague, Senior Government Advocate, Mohammed Lordship. Lordship, if this matter can come up after a week.
After
a week.
Learned counsel, so appearing on behalf of the learned Senior Government Advocate, seeks a week time for the 6 weeks time. Have you kindly informed the petitioner side?
Lordship.
The prayer is allowed. List after a week. You are for the petitioner, ma'am? You are for the petitioner? In
Yes, Your Lordship.
Item 15.
Yes, my Lord.
He's seeking 1 week's time for 1 week's
Yes, my
time.
Lord.
No?
No objection.
The petitioner counsel submits that she has no objection. List after a week.
Objection.
Lordship, I also like to mention item number 2, Lordship. This is a contempt matter, Lordship. Lordship, Lordship, I am appearing for respondent number 2, and respondent number 1 is appearing by Mohammed, Lordship. However, he has some personal difficulty today, Lordship. If this matter can come up after a week, Lordship.
You are for the petitioner.
Yes, Lordship.
You are for the respondent number 2.
I'm for 2.
Learned counsel appearing for respondent number 2. Prays for listing the matter after a week. The prayer is allowed. List after 1 week.
Hello.
Please, Lordship. Lordship, I beg to mention item number 9. Lordship, here I am for the respondent.
Okay.
I'm yet to file my objection.
It's
If
a
3 weeks time, maybe.
It's a delay condonation petition, probably.
Yes, Lord.
Item 9, the learned counsel for the respondent. 6, you want 2 weeks?
2 weeks time.
2 weeks, 2 weeks time.
3 weeks, Lord.
3 weeks time to file a written reply in the IA. Prayer is allowed. List after 3 weeks.
Lordship, I also beg to mention item number 3. Lordship, here the pleadings are completed. It is listed as admission. Pleadings are completed. If the matter can come out for hearing on the 8th of September.
Okay, so can I have?
I've taken the consent of the opposite part.
Other side. We can take it up at the time when it comes.
Sure,
It's called up. Then we can admit it. The pleadings are completed,
Sure.
right? So I'll admit the matter and post it for hearing.
Lordship.
You want a specific date?
On 8th of September, Lordship.
Okay, I'll admit it and then post it for 8th September.
Lordship. Obliged, Lordship.
For motion, item number 1.
Yes. I had perused the earlier order when the petition was withdrawn.
Yes,
right?
yes.
So, case law was also referred to, that since he was not named in the FIR,
Yes.
so he will not have the locus standi to
Exactly.
seek washing, fine. So it was withdrawn. Now, after going through, it appears that he has filed this again, agreed by the continuance of the investigation, right? And that has, this particular criminal case has given rise to a parallel PMLA proceeding. PMLA, that is his grievance. So we need to know now what is the status of investigation.
Lordship, charge sheet has been submitted.
Okay.
Yes.
Charge sheet has been submitted?
Lordship, but the thing is, the petitioners are not here.
Yeah.
Yeah.
Nobody's.
So,
Post it after
1 week.
1 week or something. So if charge sheet has been submitted, then we can seek a scan copy of the same, right? And if it is,
I
if
have,
notice is issued.
Yes, I have 1 copy of the charge sheet.
Okay, and has the present petitioner been
No.
sent off for trial?
No. Still, he has no locus standi to challenge
So then
all the process.
you may not have.
Yes,
The situation remains the same.
yes.
It is more advanced now, because even after charge sheet, if he is not sent up for trial, then he has no grievance actually. He should not have any grievance. Then he can seek, he can move the application in that PMLA proceeding. So, learned public prosecutor, so is present. However, none appears today on behalf of the petitioner. List the matter after a week.
Lordship.
In the motion column only.
Lordship.
For motion from the supplementary cost list, item number 19.
Yes, ma'am.
May I please, Your Lordship?
Go ahead.
Lordship, this matter pertains to contempt.
Yeah. 27/5/25.
Yes, Your
Order.
Lordship.
Shall we see that order?
Yes, Your Lordship.
In WPC 61, right?
61.
61, order dated 27,
Page number 21.
27/5. Within a month,
Yes, within a month.
regularization,
Yes, Your Lordship.
regularization, 30 years of service, right? But nothing has been done?
Yes, Your
Nothing has been done. Commissioner and Secretary. These two are okay. Chief Engineer PWD, Housing, Chief Engineer and Nagaland PWD. And you think a Home Commissioner would be necessary, or Commissioner Works and Housing, Commissioner and Secretary, the same person
Yes,
now?
Lord,
He's
all
holding this
necessary.
post now. Third Learned Council. Your good name, please.
Grace Ainamgi.
The petitioners is invoking the contempt jurisdiction of this court, agreed by alleged non-compliance with the order dated 27/5/2025, passed by this court in WPC 61 of 2025, in which it was directed that the case of the petitioner be considered in terms of the notification number so and so. It is in page 21. I have underlined by pencil, dated 5/3/2025. So and so. It was directed that as the petitioner was retiring, her case was to be considered expeditiously, preferably within a period of 1 month. The learned counsel submits that there is no forward movement in the matter, and with the said grievance, the petitioner has filed the instant proceeding. Issue notice upon the respondents. Steps be taken. Okay. We list after 3 weeks. 3 weeks. List after 3 weeks. Which one? Which was mentioned just now. No, I'll take it here.
Item number 3.
Learned counsel, you have mentioned. Mr. Kyo,
No, sir, on behalf of respondent.
on behalf of?
Respondent claimant.
Okay, you're for the respondent. The insurance company has filed, no?
Yes, sir.
Application. You're representing all the respondents?
Yes, sir.
All the respondents?
Oh, I'm for the respondent claimant. Respondent number 1.
Only one
No, Your Lordship. Respondent claimant.
respondent claimant. What about the others? Have they any idea about whether they have filed any pleadings?
Lordship, I've
Not sure.
taken the consent from the appellant, Lordship.
Just a minute. Learned counsel for respondent number 1 submits that the pleadings are complete
Lordship.
in the matter, and the appeal can be posted for hearing.
Okay.
Just check also. Do you have any idea whether the other respondents have been served? They've been served? I'm not sure.
I'm not sure, Lordship. Lordship, I've contacted the appellants this morning, and then he also sought the opinion that the pleadings are completed. It can be posted for hearing.
As reflected in the order dated 15/10/2024, notice was accepted by learned counsel on behalf of respondent number 1, 2, 3, and 4. Substituted service was taken. Further, substituted service by way of newspaper publication was resorted to with regard to the remaining respondents being respondent number 5 and 6, and upon completion of the same, service upon respondent number 5 and 6 was taken to be completed as reflected in the order dated 9/5/2025. Full stop. The appeal is admitted for hearing. It should be listed after how long? When should I? After how long should I post it?
Lordship, if it can be listed on 8th of September.
Oh, you had mentioned. Sorry.
Lordship.
Fixed on 8/9/2025 for hearing.
Lordship.
Lordship, I'm for the appealing, if
Oh,
my brains could be short.
Okay, sure. Learned counsel, good. Appears for the appellant. Insurance company.
Yes. Ashok Lai.
For admission, item numbers 4 to 6.
My pleasure. Although these petitions are against 3 different police station cases, issues are identical. In the sense, petitioner is the common person as a supplier, and the remaining were the person who alleged to have paid certain amount of money for delivery of goods, and that has been delivered. But, as the council have other day expressed urgency, so matter was fixed for today and attempt to be made for disposal. On the last occasion, 9/6/2025.
Three different cases, right? Three different
Three different
FIRs.
FIR in different police station
FIRs.
cases.
But similar kind of transactions.
Same kind of
So,
transaction.
tagged together.
Same allegation, and basically your lordship will find it is a shortcut method for the recovery of the amount alleged to have been due to them. On
Let us explore whether
Lodge.
we should,
On
it will be possible to dispose of
Lodge.
the stage of admission.
On 9/6/2025, the public prosecutor was to obtain instruction whether charge sheet has been filed, or
I see.
if it is filed, then scan copy. Now, so far as
We do have a scan copy, but I don't know the status of the investigation. First time taking up item 4.
4, yes.
This is criminal petition
Criminal
32.
episode 32. Here, charge sheet has been submitted as an interim order not to proceed with. Now, your lordship will find, the FIR came to be filed, at page 22. Just
Page 22.
Page 22. Married.
Go ahead.
I have done order to state that I placed an order for purchase of building material from Ajay Bahadur Singh, proprietor of Sanitary Hardware Store, Dr. R.P. Road, Dispur, Gauhati, Assam, that I deposited paid Ajay Bahadur Singh a sum of rupees 1,51,23,800 for the delivery of building materials, but unfortunately, even after payment was made in advance, the materials were never delivered to me. As such, I have faced financial loss of rupees 1,51,23,800, where the action of Bahadur amounts to cheating, hence the complaint. Now, this is suppression of the very fact that there was an agreement. Initially, there was a quotation sought for from the petitioner for supply of the building materials, and there was an agreement for taking up the construction as well as supply of a building at Dimapur.
Okay.
This very fact has been
Not stated here.
not stated, suppressed rather, and also, my lord, I have annexed with my petition the invoices pursuant to which I have delivered. My lord, the total comes to, my lord, 1,50,35,985
Invoices.
invoices I have submitted. These are all, my lord, indisputed, my lord. They have not, they have filed an affidavit in reply, but they have not disputed. And, my lord, my dues is now, I am to receive, my lord, 70 lakhs. To avoid that, my lord, now the instant FIR has been filed. Now, lordship will find
This was registered as Dimapur 17/24, right?
17/24 under section 406/420.
Misappropriation and
Breach of trust. And both are as per the apex
Yeah,
clause,
it
mutually
doesn't
excludable to each other, it is not possible.
Any race club case, anyway. that's-
And there's even the FIR Lordship has seen there are hardly any ingredients of
Anyway,
commission of either of the
let us go
offences.
into it, let's,
Lordship. Now, Lordship will find page 26.
okay. Is 26,
This is the quotation.
quotation for building materials.
Quotation for building materials, he has, the informant has sought for. So this was supplied. This run up to page 28. And thereafter, page 29, this agreement has been entered into.
Just a minute. Annexure 2 is the. it
Is the
runs from-
quotation.
From page 26 to,
28, quotation. Then from page 29 to 31 is the agreement. And also the building plan, my lord, and the drawing of the building has been annexed. Up to page 34, 35. I'm sorry, it's up to 39. So from page number 32 to 39,
agreement was with the informant
with the informant.
and the holy
Informant and the present petitioner.
wife of so and so. Building plan.
This
is the building
page 30 are the terms. Lordship will find so far as payment is concerned, clause number 10. First party to pay to second party rupees 16 lakhs for booking the materials as quoted rate for 18 months, which adjusts in billing materials. First party also ready to pay performance invoice before dispatch of the material to place. But second party also informs the first party needs goods for material before 2 to 3 days. The above material book up to so and so. Then advance, these are the terms, madam. And the rate is as per the quotation. Now building is complete. Building is complete. I am to receive 70 lakhs and odds. And to desist me, this has been filed. And rather your lordship will find the second case, Dimapur PS case number 13 of 2024. This has been filed by the nephew of the husband of the present informant. That has been filed on 7/1/2000.
This was also with regard to the building?
Same thing.
Same building?
Same thing. Claiming different amount, and they also have enclosed the materials. It's an out and out civil disputes, if any. Cannot be.
Can I have a look at the invoices? Okay.
Clutch.
Invoices.
Invoices, let's say we find page 40 onwards.
Annexure 5 series.
Clutch. Series, I have made a calculation. Of course, I could not have a separate copy. I can hand it over. These are the total I have made.
You can have a photocopy. You can make a photocopy. Keep it in the record.
This contains all the three criminal petitions.
It will be helpful. So these invoices indicate your supply?
Supply. Yeah. And these are supported by UA bill also. It is not merely I have generated, the UA bill also is given. And nowhere it has been mentioned.
According to you, the total of the invoices comes to 1 crore 50 lakhs something.
50, yes. 1 crore 50. 1 crore 50 lakhs, 35,985.69.
And you are to receive 70 lakhs by way of what? The payment, the supply.
Payment, etc. Labor component and the other the tools and machinery charges I am to receive.
Can I have the fan? Minimum speed. You made a photocopy? Photocopy. I can keep this. I can keep this.
Yes. So the first one is that criminal petition 32, Lordship will find 1 crore 50 lakhs 35,900.
32, 24. 1 crore, okay, this is convenient.
So that is the nutshell of the facts, and the law is very clear on that matter. It's a purely a civil dispute arising out of a contract agreement. And this criminal proceeding could not have been used as a tool for recovery of the amount. The FIR itself indicates she basically is agreed with the amount that she has paid and saying that goods are not recovered.
Goods have not been supplied. That is the
That
allegation.
was the allegation.
That is
But this,
their
by the affidavit, they have not denied also that these are false, these are that we did not receive those goods, etc. They have not preferred also any civil suit. And the second ground, the first is that it's a purely civil dispute arising out of the contract agreement. Secondly, it cannot be a executing proceeding for recovery of the amount by way of taking the recourse to the criminal proceeding
That cannot
by
be
not
used.
filing a civil suit. They have not filed till today. And thirdly, there are no other ingredients of either of the commission of the offence under section 420 or 406. Apart from these two are mutually excludes each other. This is the submissions subject to what the says. I will place the judgment after the submission made by the respondent side.
Anyway, so
I think respondents in the other side are same. In that case, I can submit the 1, 2, 3 together, or I will proceed one by one.
let us proceed with the first one.
Lodge.
Then it will be convenient. Then maybe facts are little, might be actual details. Just a minute. Before. Okay. Only 2 respondents, right? State, of course, is there. Prosecution. First, I can hear you. First.
As far as item number 4, that is criminal petition 32 is concerned, it has been charge sheeted. So that shows that the investigation has already been culminated in charge sheet, which means that there is a prima facie case exists. Your Lordship, as far as the state is concerned, we are confined to
Do we
the
have the
FIR.
copy? Do we have the copy of the charge sheet here? Do we have?
There will be.
There
If
should
the
be.
record-
There should be.
Yeah, there should be. On the records, LCI has been going. There. Oh,
Criminal petition 33,
Petition.
let me take it up after. We'll keep it on the side, just wait. I'll keep it with me, this one.
Lordship. Charge sheet is
You also
annexed to the
annexed?
petitioner's affidavit.
Oh.
Yes, Your Lordship.
It is there with the petition?
Yes.
With the petition itself, it is there. Okay. So according to, as per your submission, this is charge sheeted.
Yes, Your Lordship. Your Lordship, as far as the FIR is
So
concerned,
at the
Your Lordship,
time when you filed this petition, sir, so probably, you must have sought caution of the FIR, right? Because at that time it was not there.
Lodge.
At the time it was not
Very
there.
initiation of the
Any additional prayers made by way of an additional affidavit or whatever? No. Anyway.
Because I have challenged the FIR very initial stage. So if that goes all subsequent, and even if your Lordship looks into this search sheet, what I have contended, that also investigation has found that there is an agreement, that there is a transaction between.
Can you help me with the page number of your
Affidavit
petition?
in opposition, page 14.
Oh, sir, not in your petition.
No. affidavit in reply, my lord.
Oh, well, naturally, because,
Sorry, my lord, it is additional affidavit, my lord.
yeah, must be.
Page 14.
Page 40.
Page 14.
14, yeah. Got it. Ma'am, let me have a look at the charge sheet, then I'll have a look at the charge sheet.
She herself admits various transactions made between the parties. Page 16.
See, as we know, this, of course, this aspect is slightly different. It is there, it is a settled law that criminal breach of trust and criminal and cheating, they are mutually, exclusive. I think Delhi Race Club case it was laid down because the mode of transfer reason is that which has been explained by the Honorable Apex Court is that the mode of transfer of property in cheating is illegal, induced and then
Inducement, yes.
And then made to cheat, induced fraudulently and made to part with the property. But in
Right.
criminal breach of trust, the entrustment, the transfer of the property is legal. It is legally given,
Yes.
and then the offense happens.
Yes.
It is misappropriated, and then it is
Yes,
the offense
yes,
takes
yes,
place.
yes,
So,
yes.
so both are incompatible. In one there is a valid transfer, one there is an invalid transfer. Anyway, so that aspect apart. But as far as cheating is concerned, as we know that in a transaction would amount to cheating if the intention to
Yes,
deceive is
intention.
present from the inception.
Yes.
From
yes,
the
that
inception.
is right. Yes.
Should I go through the narration in the charge sheet or you submit?
No, Your Lordship, we'll be confining to the FIR because from here, whether there is any reflective of dishonest intention or these things, if
Okay.
some ingredients can be found out, then Your Lordship. The complaint at page 22, which my learned friend has already reflected here, Your Lordship.
Page 22.
Yes, Your Lordship. So I have the honor to state that I have placed an order for purchase of building materials from Mr. Aji Bahadur Singh, property of a sanitary hardware store, Dr. R.P. Rod, Despur, Gauhati, Assam, that I deposited, paid Mr. Aji Bahadur Singh a sum of rupees 1,51,23,800 for the delivery of building materials. But unfortunately, even after the payment, so there was the property was given. That means the money has been paid. Was made in advance. The materials were never delivered to me.
That
Your
is the
Lordship.
allegation.
Yes, that is reflective of criminal breach of trust, Your Lordship. As such, I have faced financial loss of rupees 1,51,23,800, where the action of Aji Bahadur Singh amounts to cheating. Dishonest ingredients is already there, Your Lordship. Hence, I am submitting this complaint for your kind information and to take legal action against Ajay Bahadur Singh under the relevant laws. So, based on this, Your Lordship, investigation has been carried out, which has culminated into charge sheet, showing that there is a prima facie case of cognizable offence, Your Lordship. So, Your Lordship, the FIR should not be, Your Lordship, quashed in the interest of
Proceedings
justice.
should be allowed to continue.
Yes.
So therefore, it will be important to see the narration in the charge sheet.
Lordship,
What has been found after investigation.
Yes.
So I'll go through it.
So, yes, Your Lordship, in fact, the modus operandi is same in all the cases. In all these three cases, the modus operandi is same. Not only the three cases, there are another two cases involving the accused involving. He is an habitual offender, and the modus operandi is same in all the 5 cases.
But he claims that the materials were delivered, taking support of invoices.
Your Lordship,
So let us see what are the materials.
Your Lordship, the complainant will see.
Have to see.
Yes.
As far as prosecution is concerned, this is your limited submission.
Yes.
So the FIR makes out a prima facie case.
Yes.
And since it has been charge sheeted, it shows that.
Yes.
Let me go through the
Yes.
narration. Have a sit, you sit down, please. You have a seat, man. I'll go. Take 5 minutes to read this. The 5 cases in Dimapur is three are by with regard to this informant
Yes,
and
in
their,
regard
and
to
their transactions.
the-
And 2 others are with regard to other people.
Yes, other people, yes, yes.
Anyway, I've gone through it mentions about the transactions and some payments. And it also says that he got subsequently arrested by Manipur police.
Yes,
And he was in jail for some time.
that's right.
And he says, his statement, he says that he could not pay because of that. And there were some transactions reflected, but in the end, they have mentioned about the 5 cases that he,
Yes.
in which he was,
Yes,
he
yes.
was, he was being investigated.
Yes, yes.
Anyway, so now I think I will hear you. This is filed by respondent number 2.
My lord, I'm for the private respondent.
Yeah,
R2.
the informant.
Yes.
Yes, yes.
My lord, may kindly appreciate that this dispute is between a private respondent who is constructing
House.
a building with a seller, a person, the petitioner who sells building materials.
Right.
Your lordship, in this matter, what is not disputed is the petitioner is the proprietor of sanitary hardware store, which is situated in Gauhati.
Gauhati.
That store sells building materials throughout the region of Northeast region. That is not disputed. It is also not disputed that I am the resident of Dimapur and I'm constructing
A house.
is a house. Now, I'm also not disputing that I've been ordering building materials from the petitioner.
Okay.
Throughout the transaction, my lord, the transaction between me and the petitioner is not confined to what I'm claiming, what I've filed, what I'm aggrieved. The entire transaction amounts comes around 3-4 crores. So,
With regard to the same building?
yes, same building. I was aggrieved only the petitioner failed to make the delivery of the amount which I've reflected in the FIR, which is 1 crore 51 lakhs some thousands.
He failed to pay you the amount
I'm not aggrieved by the amount.
for the materials.
Yes, your lordship may kindly note that this issue is not with regard to payment, it's regard to non-delivery of the materials which I have paid. The petitioner as the seller, he is obliged.
You paid, but he has not supplied. the
Yes,
materials. That is the grievance.
Yes, that is my grievances. Now, before I delve into the, make my submission, may I kindly be allowed to introduce the petitioner? My lord, may kindly note that item number 456, which is listed today, belongs to the petitioner, where the same allegations based on building materials, non-delivery of building materials has been alleged against the petitioner. Therefore, the petition is before this honorable court, seeking questioning of all those. Yes, 3, 4,
And
5.
that's what I'm just repeating one question. It's all the 3 cases pertain to the construction of the same building,
Yes, yes. No, different.
different buildings.
Yes.
Separate persons.
Separate persons. I
Yes,
see.
yes.
Persons
Not
and,
the same person.
Different materials.
This particular respondent number 2 informant, her house in Dimapur.
Yes.
This is the criminal petition.
Yes,
The
yes.
other 2 are different.
Now, may I, Your Honor, may kindly come to my written objection
Yeah, I'm on that.
at page number 15. Just to introduce who the petitioner is, my lord. Page number 15.
Pencil.
Of my written objection, page number 15.
Yeah.
May I, my lord? Now this is, it is evident here, my lord, the petitioner is not before this honorable court for the first time. In the year 2023, same incident has happened. So the aggrieved filed an FIR, and then based on that, the petitioner approached this honorable court, and through this order, they said the proceedings was quashed on the ground that they were out of the settlement. Well, same allegations, my lord.
Same allegations. were made.
Yes.
this was settled, this dispute was
Yes,
settled.
yes. It was quashed only on the ground of settlement.
Settlement.
Yes.
This was both parties say, and the opposite party said that.
But the fact remains that, my lord, same allegations.
Okay, anything else?
Yes, my lord. Now, just for the perusal of this honorable court, a case has been registered again against the petitioner in Manipur, in Pal. I have that order if I may be allowed to, just for the perusal. Now FIR in West Impal, my lord, has been registered. Chief Judicial Magistrate West Impal has issued non-bailable warrants against my lord. May kindly see that in the capacity Ajay Bahadur Singh, proprietor of sanitary hardware store, against him and his wife. Now, so this case is also pending in Manipur. The last page reflects the present state of the case before the Honorable Manipur High Court.
This is the subject, are you aware of the subject matter of this petition?
Yes, yes, yes.
Same
If it's personal, then the sanitary proprietor would not have been mentioned, my lord. I kindly note that.
Anyway. What else have you stated in the
Yes, my lord.
written objection?
Yes, I'm not disputing that several transactions. Petitioner has also made several deliveries, but I have no issue with that. My problem arose when he failed to make the delivery of the amount which I've reflected in the FIR, my petition, my lord.
Remaining
Yes.
materials. But won't that
My lord,
make
can you
it
come to my petition?
no, but there was an agreement and
I'll come to that, my lord. I'll satisfy you on that, but kindly let's reflect on the FIR, my lord. At page number...
fire we had already seen. I'll see it again.
Yes.
I'll see it again.
But this is the complete set of the FIR which I filed before the police.
Page.
Page 9, no, an extra of my objection, my lord.
Page 9.
Yes, my lord, may kindly appreciate that this FIR was filed by a private citizen.
Okay. Placed in order for.
So it reads as, I have the honor to state that I place in order for purchase, my lord. It is very apparent. I purchase of building materials from such and such that I deposited paid such amount for the delivery of building materials, my lord. Time and again that has been reflected. Kindly come to next page, my lord. Next page, page 10. Now a chart has been also, I also filed a chart which states that the amount has been categorized along with the materials which the amount was paid for.
Okay. And
Can you come to next?
out of these payments,
Yes, some has been paid in cash also, my lord.
no, none of these materials have been supplied, or some have been
Yes,
supplied.
no.
Nothing has been supplied.
Yes,
But earlier, some materials were supplied.
yes, I'm not disputing that.
But
We have piles of invoices as well, my lord, but that is not in question. Now, can you come to page 11? 11, 12, and 13, my lord, the receipt through which I made the payment. So I filed this entire set before the police station, and based on these allegations, my lord, may kindly appreciate that I'm not seeking for any recovery and repeatedly addressing that I've ordered for building materials that has not been paid. The amount is such.
Okay.
Now, my respectful submission is, my lord, the petitioner is a seller, nothing else. He sells building materials throughout notice. May I kindly take you to the agreement filed by the petition?
From his pleading?
Yes, page 29 of the petition of the petitioner. Page 29. I'm also not disputing this document, my lord. Now, mere perusal of this document will only prove that this has been executed in the interest of the petitioner. The petitioner has already read through the entire document, so I won't, but it clearly states that the requirement which will be needed, my lord. It has been stated clearly, 1, 2, 3, entire thing, my lord. Now, the interesting part, my lord, can you come to the last page, page 31. Why I'm saying the petitioner is just a seller is because witness has been done by the building contractor, the one who is building my building, who's constructing my building.
Page 31.
Page 31, Azad Hussain. Phone number is there. It's clearly written, building contractor, my lord. Now,
Witnesses.
yes,
One of the witnesses.
now to supplement this, kindly may I take you to the charge sheet filed by in additional affidavit. Page number 17, my lord. Relevant operative part. I'll be brief, my lord. Page number 17. The last paragraph and last two stanza. May I be allowed to read, my lord? In the middle of the month 2020. Has my lord got it?
Fine, just a minute. In the second paragraph.
Last 17, last paragraph. But it starts from the middle. In the middle of the month 2020. Has my lord got it? Page number 17, last paragraph. Middle sentence. It starts from the center, my lord.
Got it.
Yes.
In the middle of the month of 2020.
Mr. Sachs called him up and told him he had a land in Dimapur and he wanted to construct the RCC building at there, and for which he wanted to meet him, and accordingly he came down to Dimapur along with a building contractor, Mr. Azad, my lord.
Okay. And this Azad was one of the witnesses.
Yes, yes. So,
You know, you complete.
now, my lord, I have not filed the FIR seeking. I know that police is not for recovery. I'm aggrieved the way, the manner in which.
You think that he has
Yes.
cheated you?
Yes, yes, yes. So I filed an FIR. Now, against that FIR, during the pendency, the petitioner approached this honorable court, and during the pendency of this petition, it has been charged that now 12 grounds has been taken by the 12 grounds, my lord, has been taken by the petitioner.
Before I go further, I just want to help me with one aspect in the charge sheet.
Yes.
5 cases have been mentioned, right?
Yes, yes.
So out of these, which 3 pertain to this criminal petition? This is 32. This is 17 of 24. Dimapur PS case number.
Will be 43 at page 19. This
5 cases in Dimapur police stations.
these numbers are
SBN
given.
PS case
43 of 2023.
43.
That has been compounded
as
friend has referred.
13 of 2024 is a subject of another connected criminal petition, right?
13 is with regard to criminal petition number 33 of 24.
33 of 24.
24. Criminal petition.
Another one.
Another one.
And then East PS case number 5 of 24. West PS case number 2 of 24. These are 2 different cases.
Criminal petition 34.
2 of 24 is item number 6, right? And 5 of 24 is, this is also a connected criminal petition?
No.
No, this is not. This is a different matter.
It's only 13, then as well 17, and
13 of 24,
13 of 24,
17 of 24, and 2 of 24.
and 2 of 24.
And 2 of 24. And these are other cases. 43 has been compounded.
43 has been compounded. And now, therefore, the other FIR came to be filed. To follow this suit, I sit for compounding the offences, pay the amounts without on coercion.
My lord, that is not the intention. Nonetheless, may I be allowed to complete my submission?
Yeah, surely.
My lord, so the petitioner has taken 12 grounds stating that this FIR and criminal proceedings initiated against the petitioner is not maintainable, but these 12 grounds has been premised upon 3 basic principles, which is first is FIR doesn't prima facie disclose offense, alleged offense. Second is with regard to jurisdiction, the petitioner is stating that even if it is to be assumed that alleged offense has taken place, the place of commission is Gauhati, since the office is situated there, though, so the jurisdiction lies there, and then
It was to be
civil
delivered in
nature.
Dimapur.
Yes. Now, I've submitted my list of authority, but for the convenience of this honorable court, I've prepared a gist. May I be allowed to submit?
You are not disputing the invoices.
I'll come to that, my lord. Authority number 1, my lord, FIR. The petitioner is, the first ground taken by the petitioner is that FIR doesn't discuss prima facie offense, but it is settled, my lord. Authority number 1, the case of Tapan Kumar.
Right.
FIR is not an encyclopedia which must
certainly.
disclose all the facts.
That's well settled.
Yes. Number 2, principal object of FIR is to set criminal law in motion and to obtain early information. Now, in my FIR, I have submitted documents, the bank transactions, the list categorically stated I paid for this. And then in my FIR, I have also stated that I've paid for building materials. So my respectful submission is the first ground taken by the petitioner, which is FIR doesn't prima facie discloses alleged offense, is not maintainable. Now, second ground taken by the petitioner is territorial jurisdiction. My lord, section 19 CRPC, now section 199 BNSS clearly reflects that offense triable where the act is done or consequences ensues.
Right.
I'm not disputing that the place is in Gauhati, but it is also disputed that the petitioner was supposed to make those deliveries in Dimapur. So the consequences has ensued in Dimapur. Can you come to next page, my lord? So to substantiate the submission, I've enclosed authority number 3. Relevant paragraph is paragraph 20.6, in which the Honorable Apex Court has stated where something is an offense by reason of act done as well as the consequences that ensued, then the offense may be inquired into or tried by a court within whose local jurisdiction either the act was done or the consequences ensued. My lord, next authority number 4. In this case also, my lord, this is a material dispute. But the facts in this case is, in the case of Suresh Kushal is, the marriage took place at Jabalpur. The couple resided at Indore. Alleged physical torture took place as Indore. So the wife came back to Jabalpur. Miscarriage took place at Jabalpur. The criminal case was filed in Jabalpur. Now, FIR was filed, that was quashed, the complaint went to High Court, and the Honorable Apex Court has held that in paragraph 6, my lord. Above section 179 contemplates 2 courts having jurisdiction, and trial is permitted to take place in any one of those 2 courts. One is the court within whose local jurisdiction the act has been done, and the other is the court within whose jurisdiction the consequences has ensured. When the allegation is that the miscarriage took place at Jabalpur, it cannot be contended that the court at Jabalpur could not have acquired jurisdiction, as the acts alleged against the accused took place at Indore. Now, it is amply clear, my lord, with regard to jurisdiction. I'm not disputing that the petitioner has his story in Gauhati, but that those deliveries.
Yeah.
So, the second ground taken by the petitioner that with regard to jurisdiction is also not maintainable. Now, the final ground taken by the petitioner, which is civil in nature. My lord.
Yes.
Yes, my lord. Now, authority number 6, my lord.
Absolutely. Yes,
Yes. So, The Honorable Apex Court has held that an act can result in both civil and criminal liability. Hence, merely because the act has civil liability, that does not mean that it cannot have criminal liability. My Lord, authority number 7, this is irrelevant. The facts in this case is, complaint was registered under false evidence, criminal breach of trust, forgery for the purpose of cheating. Now, magistrate took cognizance in the case of M. Krishnan, my Lord. Magistrate took cognizance and issued process. Now, the accused approached the High Court to quash proceedings on the ground that pending civil case was pending, my Lord. On the same issues, High Court quashed the criminal proceedings, complainant approached the Apex Court. Now, this is the consideration. Paragraph 4, 5, 9, and 11. In all cases of cheating and fraud, in the whole transaction, there is generally some element of civil nature. If mere pendency of a suit made a ground for questioning the criminal proceedings, the unscrupulous litigants apprehending criminal action against them would be encouraged to frustrate the course of justice and law by filing suits. Such course cannot be the mandate of law. It is settled, my Lord. Now, in our case, there is no civil case pending. No case whatsoever has been registered. Second, my Lord, authority number 8. In this also, with regard to civil and criminal, the Honorable Apex Court in J. Jagdish has held that relevant paragraphs 8, 9, 10, 11, 12, and 13, same set of facts may give rise to remedies in civil as well as in criminal proceedings. Even if civil remedy is availed by a party, he is not precluded from setting in motion proceedings in criminal law. The two remedies, this is important, my Lord, the two remedies are mutually exclusive and clearly coextensive and essentially differ in their content and consequence. It is an anathema to suppose that when a civil remedy is available, a criminal prosecution is completely barred. Now, the third ground, the final ground taken on this settled principle, may I respectfully submit that is not maintainable. Now, with regard to invoices, documents produced by the petitioner, my Lord, may I kindly reiterate that the entire transaction is not limited to that 1 crore 51 lakhs. It comes around 4 or 5 crores. But with regard to the filing, the documents adduced by the petitioner, the Honorable Supreme Court, authority number 9, my Lord, in the case of Rajiv Kowar, has held that it is settled evidence. It is settled that evidence produced by the accused in his defense cannot be looked into by the court, except in exceptional circumstances. Authority number 9, my Lord. Except in exceptional circumstances at the initial of criminal proceedings, it is straight law that High Court cannot. Yes, High Court cannot embark upon appreciation of evidence while considering under 482. It is settled, my Lord. The documents, yes, I have already disputed those are fabricated, has been adduced to meet the needs of the, but regardless of that, those documents cannot be considered. That is my respectful submission. Now, since this application is filed under 482, now 528, my Lord, which is questioning of FIR and consequential proceedings, may I take you to authority number 10, my Lord, my authority number 10. In the case of Jitulal, Gentilal, Kotek, the Honorable Apex Court has held that High Court must exercise its inherent power under Section 482 sparingly and with circumspection, my Lord. Paragraph 29, the test to be applied is whether the allegation in the complaint as they stand, without adding or detracting from the complaint, prima facie establish the ingredients of the offense alleged. My Lord, may kindly appreciate that I have the documents receipt. I have categorically charted the required materials, and in my FIR application, it has been repeatedly said that is for building materials. At this stage, the High Court cannot test the veracity, my Lord. May kindly appreciate the veracity of the allegations, nor for that matter, it can proceed in the manner that a judge conducting a trial would on the basis of the evidence collected during the course of trial. This is the law is already settled, my Lord. So my respectful submission is the petition of the petitioner is not maintainable and liable to be dismissed with exemplary cause, my Lord. Now, may I kindly be allowed to revert to the case which was addressed by the petitioner. My Lord, it's not in my list, but may I be allowed to file one, submit one case law? May I take you to, I've already marked that page paragraph 20 and highlighted, my lord. The Honorable Supreme Court in Ajay Kumar Tyagi has held that the decision is an authority for what it actually decides and not flows from it, my lord.
Yeah.
So, coming to the case referred by the petitioner, which is Delhi Race Club. My lord may kindly appreciate that in the instant case, the issue is between a person, a common citizen who is constructing a building against a person.
That is the general principle.
Yes, yes, yes. That is the general principle.
Delhi Race
Now,
Club,
in this case,
pertains
Delhi
to
Race.
cheating and criminal
Yes,
breach of trust.
but my lord, the facts is important, my lord. So in the case of Delhi, the complainant is a firm in the Delhi Race Club, okay? My lord, pardon, my lord. Complainant is a firm and the accused is a company. The complainant firm sells horse feet, barley and oats to the accused, my lord. So the complainant, which is a firm, used to sell for money, my lord. The accused, which is the company, did not repay, so this dispute came up to the Honorable Apex Court, and then the entire criminal case has been quashed. That is not disputed, my lord, but the facts is important. Now, in this case, the Supreme Court has set aside the impugned order of the High Court, an order taking a complaint, a private complaint was filed, my lord. But in this case, the order taking cognizance upon the complaint by the additional chief magistrate was quashed, but not the complaint, my lord. May kindly note that. And then, yes, it is also not disputed that in this judgment, the distinction has been made between 406 and 420. But yes, it has been held that 420 and 406 cannot coexist in the same facts. They are not twins, that they cannot survive. But my lord may also kindly appreciate that they have not made any observation with regard to laying down any direction that if in any FIR or complaint where both 406 and 420 exists, that will be quashed. No directive whatsoever has been laid down, my lord.
No, a court can frame alternative charges.
Yes, yes, yes. But that is not fatal in nature. That can be with regard to provisions, relevant provisions, appropriate provisions. The trial court can do that, my lord. Now, just because 406, 420 has been clubbed, will that be reasonable? Will that be just in the interest of justice if an entire FIR and criminal proceeding is quashed? My lord, my respectful submission is that will set a very dangerous precedent, my lord. I have not filed the FIR to claim any amount. I was aggrieved because I've contacted several times the petitioner. My lord, may kindly appreciate the antecedents of the petitioner. Not only here, he is also famous in Manipur, my lord.
You have contacted?
Yes, I tried. I'll tell him where he is, because I'm constructing and with all due respect, the building is not completed, my lord.
You have not been able to contact him?
No, I contacted, but he made himself unavailable, my lord. The first thing any reasonable person will do is confront the person. So I did that, but he was not available. He might have thousands of excuses, but that doesn't give him any right, my lord. He is a seller, he sells building materials. I've paid my money. So if a person who has paid his money for certain products is being refused, is being denied, that is criminal, my lord.
Anyway.
So my respectful submissions, the petition whatsoever is not maintainable. So kindly dismiss this petition. Oblige, my lord.
Just 2 points. Two points from the side of the court. Generally speaking, if there is an agreement between two persons for a business transaction or mercantile transaction, and say supply of goods or whatever, and pursuant to that agreement, some payment is made, supplies are made, and in between, suppose there is a stoppage in that supply, on the prima facie, it is from the civil point of view, it is a breach of contract. From the civil point of view, okay, it is a breach of contract. That the contract was very simple. That between two persons, that I need some materials, I will pay you money and you will supply. Suppose the transaction starts, money is paid, supply also starts, and then in between, at some point of time, it stops. So from the civil point of view, as I said, and I'm repeating, it will be a breach of contract. However, to ascertain as to whether that kind of transaction and that kind of development of stoppage of supply amounts to cheating, the ingredient of the accused person, having that intention from the inception has to be there. And there has to be some materials. See, it would be, at the trial, if the trial commences with regard to such an issue, the determination of whether he had the initial intention would require some evidence.
Yes,
right?
yes, my lord.
But in a quashing proceeding, if that aspect has to be determined, because as you rightly pointed out, taking support of case laws, it is well settled that appreciation of evidence is not our domain,
Yes,
right?
yes,
Because
exactly.
there cannot be two parallel trial systems, right? So appreciation of evidence is not our domain. We all accept that. However, if a court is asked to quash criminal proceeding in that kind of a situation, where there is also an element of breach of contract, then we have to see whether there are any materials prima facie, without appreciating evidence, whether there are any materials prima facie from which the court can infer that he had a dishonest intention. If there are some prima facie materials to infer that he had some dishonest intention to do this, then the matter has to go for trial. However, if there are no materials, however, if there are some materials, prima facie materials, to satisfy the court that there was no such dishonest intention, then it will be purely a breach of contract.
Yes,
Then there will be the criminal element won't be there.
Yes,
So
yes.
now, I would seek the assistance of both the learned counsels to help me adjudicate on that point. That now there's no dispute that there was a transaction. There was no dispute that there's an agreement. There was no dispute that money was paid. There was also no dispute, apparently, that there was some supply, but it stopped. And the informant was very agreed. The informant thought that she has been cheated, and therefore this has been filed. So both the learned counsels will kindly help me, with your respective cases, to see whether there is what are those materials from his point of view. What are those materials which indicate that he did not have any intention from the beginning, and from your point of view, what are those materials which indicate that he had an intention? This is the point on which this proceeding will have to be decided.
Yes, my lord.
In my humble opinion.
Yes. I really appreciate, my lord. Now in this case, my lord may kindly appreciate the agreement produced by the petitioner. It doesn't define any relationship except the fact that I'll order this much, he'll pay, and then it has been witnessed by the contractor. If, suppose, in the agreement there were clauses referring to disputes, allegations, that is different thing. That is not there. Second thing is, my lord, FIR. Question petition FIR is very crucial. That is crucial. So FIR, I have already submitted the transaction, my lord, bank receipt. As a layman, the best I can do, that's the best I can do. Now, the third thing is, my lord, the history of the petition is very important, my lord.
In this respect, I have one more query from my side. Now, I have not started going into the other two materials, other two cases. In those proceedings, also whether I believe the informant is different, right? The private respondent is different. So in those cases also, is the factual situation similar, that after some supply, he stops supplying, and then the grievance starts?
In the earlier,
it is
in
similar.
2023 as well.
Is
the
it
case
similar?
which has been disputed. Yes, my lord. It's not disputed. Even in 2023, which has been reflected.
So that is what you mean by the same modus operandi? That the similar modus operandi?
Yes, my lord.
That after some supply he stops?
Yes. Basically, he's been doing that. In the FIR, in his statement, he's also alleged that he was in financial crisis.
Yeah, I've read that. That is also reflected in the
Yes, my
charge sheet.
Yes.
in his statement.
Now, I'm not disputing that there might be some flavor of civil in it, civil remedies available. But just because there are civil avenues available, will that be
No,
the
but
ground?
that's settled.
Yes, my lord. So that is,
A transaction can have both dimensions, but for the
Yes.
purpose of 482 vis-a-vis this kind of matters, as I said, say we are with cheating at the moment, we have to see, that without the advantage of appreciation of evidence, we have to see that what are those materials which give an answer to that question, that whether he had the intention to deceive from the beginning. That will be the deciding point actually. Though that is the decisive question. If there are materials on this side,
My lord,
then
at
it's a
this
civil
stage-
dispute, it's a breach of contract. And if there are elements to indicate that yes, it may be a breach of contract, but there is an element of cheating, then I cannot quash.
My lord.
It has to go for trial. then.
at this stage, it would be very impossible to come up with such documents. It's just that the entire scenario has to be considered. He has been refraining from making the delivery, my lord. That proves something. That shows something.
Because there have been cases. See, there are many judgments, as you know, very learned counsel, both sides. All those cases, whatever little I have read and experienced, in all those cases where in this kind of situation, there has been the criminal proceeding has been quashed. The court has come at a finding that these are the materials. These are the materials. Suppose a person becomes, he disappears from that place. He changes his contact number. For the small examples. The court has arrived at a finding on the basis of some materials that there was a dishonest intention. In those cases, it has not been quashed. Where it has been found that yes, there are no such materials. It appears to be basically a civil dispute. Then it has been quashed. So this is the thing.
3 cases in Nagaland, 1 case is in Manipur, my lord.
That is an aspect of concern, no
Yes,
doubt.
yes.
That is an aspect of concern.
Now, with
That
regard,
is why I asked this question. I don't know whether it was unfair to him to ask that question, but it came to my mind. So
Yes,
we are
yes.
having an open deliberation. So I asked this
yes,
question. That in the other two also, is it the same nature that after some time he stops? He has been stopped. Same like this.
The issue is trying to prove that they supplied the materials by an excess of e-gifts. But whereas the complainant is not receiving materials.
At all. Anyway, so I think these are the submissions from your side broadly. And you have, let me hear his reply. Then we'll close the hearing in this and take up the other one. One matter I can dictate here, but all three may have to be resolved. Anyway.
My lord, firstly, my lord, in the case of my lord Harsendra Kumar, my lord, it has been stated, my lord, what are the documents to be looked into? For the purpose
Which
of
case? Which case?
It's 2011 CRLJ. I'll just give a copy of it. I'm relying on paragraph 21.
Yes, yes. Public documents or of unimpeachable character and otherwise he has relied upon that decision which says that generally defense documents are not relied upon these days.
Which are beyond suspicion or doubt or admitted documents. Those can be relied.
Can be, yes.
So here, my lord, agreement is not denied. My lord, my invoices are not denied. Agreement was entered into 2020. Invoices which I have annexed, those are of 2023. And to justify his amount, he is relying on some of these invoices or the bills or the dates of 2021. When, my lord, 2021 itself, I did not deliver any goods. Why should I deliver, my lord, subsequent to, my lord, in 2022, 2023?
Okay.
At no point of time he ever said in 2021 that those goods were not supplied, etc. And it's a building construction carrying on from 2020. the agreement clearly says it is not only for the supply of the goods, but also for the construction work that would be carried out, the labor component, etc. If your lordship goes to the agreement once again, page 29.
So why is he having so many cases? That is
Well,
also
he's,
a matter
no,
of
my lord,
concern.
see, my lord, he is a seller, my lord, he is a dealer, rather throughout the northeast. And these
Because
are, my lord,
the informant is different in all the three cases, right?
yes, yes, yes. But I am supplying throughout northeast, my lord. There may, my lord, this commercial disputes may arise. Many a times in one of the case, the dispute is that the wrong material supplied, not the quality what I had supplied. That is one of the dispute, my lord. So this dispute definitely will remain, my lord. So it's a commercial transaction. I will supply, either they will not pay or I will not supply. That is the allegation will always come, and it is always governed by an agreement. It may be oral, it may be written.
True.
So just because I am having a dealing throughout India and different cases in different states, that does not mean that is my modus operandi. Rather, in the cases of these three, and another case is listed for hearing, your lordship will find this is the modus of my lord executing for recovery of money. In these three cases, comparison table I have made, how I have been arrested. I have been arrested in 43. This
Which was compromised.
Which was compromised. Their amount was 11 lakhs and all. So after doing my lord, these cases and all, filing the cases, my lord, for all good reason, I think that let's get it over. 11 lakhs, let it compromise. I don't know what is the terms of compromise, but then compromise. It was only 11 lakhs off. The records is available in the court. I have the petition also. I can place before your lordship. Now, just for an overall view of the these three transactions, because lordship is maybe appreciating his contention that that is my modus operandi. Of,
No, I did not say that. I have no right to say that. I'm asking him.
Lordship, because first of all,
That will be prejudging the matter.
no.
I just asked.
Lordship, so first of all, he is this senator is a big dealer of the Northeast region. He has transaction losses in Manipur. Even some cases are in Gauhati. That is bound to be there. In fact, legal department is also there in many commercial houses or the establishments, only to deal with the cases, arbitration, etc., etc. It is bound to be there. Commercial disputes. This is one of the commercial disputes only. Now, comparing to these three cases, what have been listed, your lordship will find in case number Dimapur, case number 43 of 2023, I was the FI was lodged on 17/7/2023, and I was arrested on 11/1/2024.
After a considerable period.
I was a considerable. Then I was released on bail on 26/2/2024. In the same police station, this present case was pending, was never intimated to me. Well, it's a well settled judgment of Jammu and Kashmir. If one person is arrested, then all the cases has to be intimated to him, not that one by one, etc. Now this. Now here your lordship will find this relates to Dimapur PS case number 13 of 25. FI was lodged on 7/1/2024, same police station. I was arrested on 11/1/2024. I have not been shown arrested, nothing. But then this FIR came to be registered only on 26/2/2024 when I was released on bail.
No.
And on 27/2/2024, I have been shown arrested. Subject to correction if any dates for any reason. And on the same date, I was released on bail. My lord, sorry, my lord. The present case relates to, my lord, case number 17, my lord, or not 13, 17, my lord.
Presents to
Lordship, my lord, here-
1724.
Lordship, my lord, Lordship, may I skip, my lord? FIR was lodged on 26/2/2024. The day I was released in the other case.
I get it.
And I was shown arrested on 27/2/2024. And prior to that, on 7/1/2024, that Dimapur PS case number 13 of 2024 was filed. That relates to criminal petition number 33 of 24. And who has lost? It is lost by the nephew of the husband of the informant. by the
Nephew of the informant.
husband's nephew. That was lodged on 7/1/2024, but it was never registered till 26/2/2024. On the same day, both the cases were registered.
Okay, anyway, so
And in 34, your lordship will find the other criminal petition. Their FIR is Dimapur PS case number 2 of 24. That was lodged on 8/1/24. Stated. But if your lordship looks into the FIR, it was actually lodged on 14/3/2024. But I have been shown arrested on 11/1/2024. Well, a cart before the horse. Well, that 43 or that 24, I'll highlight your lordship. I'm just giving an overall view, my lord.
43, which was compromised
Lordship.
with the order of this court.
Also, once they are thinking that
That order is part of his petition.
Yes.
Objection.
Yes,
This 11/6/24, criminal petition. Yes, you just showed me, right?
yes.
Which was-
Arising out of criminal PS case number 43 of 2024. Now coming back to this, my lord, your lordship will find, my lord, the agreement once again, my lord, 29.
The agreement.
Agreement. It is between the informant and me, not the contractor. My friend tried to impress upon that building contractor is somebody else.
No, one of the contractor is a witness.
Yes, my lord, he in fact has.
Even in the charge sheet, my lord,
My lord, he.
charge sheet, one with the building contractor, Mr. Azad Hussain, it's clearly reflected.
He is in the charge sheet.
In the charge sheet, earlier we read the last paragraph,
No, I'm
page
not-
17.
He is a witness in the agreement.
I'm not disputing that he is the contractor.
But he is a witness in the agreement.
But the agreement is, my lord,
With the
with me.
petitioner.
Payment, everything comes with me.
Oh, that's
He-
okay. It's written like this.
Yes,
It's written also.
he is the contractor.
That is written also.
So my submission, what I
Between
said,
Tohili Kids and Ajay Bahadur Singh is written also.
and the terms for a moment once again, serial number 5, labor payment every week of Saturday in running period. Then serial number 11, Rajmistri advance need 1 lakh. 12, other labor also need advance at time started of so and so.
My lord, those issues are fit before the trial court, my lord. Who paid who, what, how much, my lord. Now my last and respectful submission is, my lord, the petition is saying this dispute is commercial nature. Yes, from his point of view, it might be commercial because he's a seller, he sells in return of money, but not in my case, my lord. I'm constructing my building. I'm a genuine normal citizen. So that is my case, my lord, basically.
And the other aspect, your lordship will continue.
No, sir. I'll take a break after some time.
Lordship will come to paragraph 10 of my petition,
Complete this hearing.
page 9
Page 9 of your petition.
of my petition. Well, third line from bottom middle,
Okay.
from middle portion, on the basis of their agreement, the petitioner has completed 8-story building as required for the informant. The informant also paid some amount for different sources as a cost of the materials from time to time. After completion of multi-story building, the petitioner requested the informant as her husband, Mr. Kotoho Sumi, is to clear his outstanding amount of rupees 70 lakhs, which he paid for labor, carpentry, and for other material, etc. But this has not been denied by them by filing the affidavit. He has not said so.
My lord, everything is disputed. These are disputed question of facts, and under 482, disputed question of facts cannot be entertained, my lord. And respectfully, my lord, the statement made by the petitioner, the accused, in his statement, and the petition are totally contradictory. On one hand, he's admitting in this petition, he's stating that, in fact, I owe him 70 lakhs, and he's claiming that I am hand in gloves with the police, my lord. But nonetheless, my lord, those are disputed question of facts which cannot be considered under 482. That is my respectful submission, my lord. So this petition has to go in the interest of justice, my lord, in all fairness.
My lord, so far as that, my lord, the Delhi Race Club case, my lord, it is the ingredients that are required to be, my lord, evaluated for the section 420 and 406, my lord, stated, my lord, in paragraph 30.
No, that alternative charge, can be framed.
Yes, yes.
But
yes.
a
Not
person
both.
cannot be convicted for both the sections together.
Both the sections. That is-
One
that is-
without. But alternative charge can be convicted.
Yes,
Can be
yes, my
framed.
lord. Relevant paragraph I've marked in Delhi race case. Shall I? Can I, my lord?
Yeah, sure. Why? He's also submitted AI copy. Okay, I'll give it back to you after that.
Those are just relevant paragraphs, my lord. To show that between company and firm, the dispute is purely commercial in nature, which is not the case, which is not our case. The petitioner is a seller, but I'm not purchasing those for profits.
Okay.
Obliged, my lord.
One judgment that that's of VUI just very well leading cases, my lord. VUI just AIR 2009 Supreme Court Supplementary 59. And I am relying on paragraph 15 regarding pure contractual dispute of civil nature and offense of cheating.
Para 15.
Para 15. Then paragraph 18.
Just a minute. Para 15, para 18.
Para 18. Para 19 and 20. A matter which essentially involves dispute of a civil nature should not be allowed to be the subject matter of a criminal offense. Paragraph 18. Then paragraph 19 minute. And 20. Then one more judgment of recent, but this has not been reported. We have got it from the live law. It's a court copy of course, having the 2025 INSC 86.
Don't worry. So INSC citations are encouraged also nowadays. The court's own citation. Or we also have high court.
But I'm relying on the paragraph 13 and 14. We also inquired with the learned counsel appearing for the respondent where his client has filed any civil suit or has initiated any other proceeding or recovery of money. It appears that no civil suit has been filed for recovery of money till this date. Money cannot be recovered, more particularly in a civil dispute between the parties, by filing a first information report and seeking the help of police. This amounts to abuse of process of law. And 14, we could have said many things, but we refrain from observing anything further. If the respondent 4 has to recover a particular amount, he may file a civil suit or seek any appropriate remedy available to him in law. he cannot be permitted to take recourse to the criminal processing. This is also similar on the transactions, my lord.
My lord, is
Then
this
one more,
MS
madam.
Shikhar Chemicals?
One more, my lord, judgment.
No, Shailesh Kumar.
Oh, I'm so sorry.
You can have a look if you want to.
No, it's
We'll give it. You can take mine. Then another, my lord,
There are many judgments like this because
Yes,
these
yes.
issues keep coming before the court.
My lord, but in MS
Here-
Shikhar
here
Chemicals,
only-
the complainant is affirmed and the accused is also affirmed, my lord. Facts, it's
Shikhar
very
Chemicals.
important.
but in this case, I am relying on paragraph 14. The facts is, my lord, in
Para
paragraph
14 of, you submit that, okay? Shailesh?
Shikhar Chemicals.
Okay, para 14 of Shikhar Chemicals.
Shikhar Chemicals. Isn't it? My lord, this is also sale transaction regarding, my lord, paragraph 11, it says,
So what is the date of this order?
this is of, my lord,
Reflected.
4th August 2025.
Is this?
4th August 2025.
What is it written? I could not find it. Yes, there are-
Continue the
Date
page,
is also-
page 16, bottom, my lord.
Oh, so this is an additional part. Because always it is here. No problem.
This is also another sale transaction. And in paragraph 14, it says, it was expected of the additional CGM to know that in a case of sale transaction, where is the question of any entrustment of goods so as to bring the case within the ambit of criminal breach of trust punishable under section 406 of IPC. Now, if we revert back to the 420, as your lordship has rightly pointed out, the deception has to be at the beginning.
No, in a case like this, cheating would be made out, may be made out in a situation like this. That suppose the person enters into an agreement, and he will get some money, he will supply, but he knows, I'm thinking in my mind that after some time I'll stop supplying. Then it will be cheating. If at the inception,
Well, that
Given the history of the
intention-
petitioner,
that
it would not be
particular
wrong to
intention
assume.
also should have be at the
inception, yes.
At the
That part
inception.
that part of the inception, if there's an intention like this, that I will supply, suppose, no?
I'll supply
But
initially,
then I will
proceed.
stop.
Then I'll stop.
That kind of intention has to be there. Secondly, from the inception,
From the-
then this will have to go to trial in situation like
In
this.
the situation. like
My lord,
this.
history
Now,
of the
here the
petitioner.
situation is,
History of the petitioner.
And that is one issue
now
that's
here
there.
is the, now here is the situation, well, I'm just summing up.
He's having multiple, even giving him benefit of doubt, multiple breaches of contract. Suppose.
I'm
That
just-
should not be for a good businessman, but anyway,
It happens,
it has happened. It might have happened, but again, that is an aspect.
Disputes are with commercial.
That is
banks.
what the IO has said in the end. IO, in the end, one of the reasons for sending him up for trial is that reason
So
only.
that could not have been, my lord, that could not have been. And one of the summing up what I submitted, the documents he has annexed, the payment or the material which are not supplied, those relates to 2021.
Okay.
And this, Lordship will find FIR is filed on 26/2/2024. Transaction of 2021. FIR is filed 2024. 3 years by now, complete.
This is in which case?
This is the instant case.
Instant case. Okay.
That's all.
This will require some considered deliberation, considered thinking, and then I'll have to think about it. So I would not prefer to dictate here. So I'll reserve the judgment. Petitioner is represented by learned counsel. This assisted by heard learned PP. Learned counsel appears for the respond number 2/informant. The heard arguments addressed by the respective learned counsels. Judgment is reserved. This particular class is reserved. Because I'll have to go through this entire thing and think about it. It'll be better.
In order to they were to produce the charge sheet or not charge sheet.
Can you keep it? Then you now the citations also. It will be better if we keep it in a separate file board. Separate file board. Is judgments. What is the next connected matter with the criminal petition 33?
33.
33. Okay, same.
Yes, same. Just there are some amount is different.
Amount is different. The informant is same.
Same.
No, informant is in the same, different.
Oh, informant is different.
What the council is presenting.
Yeah, council is.
Counsel
Yes,
is.
I'm representing for.
Counsel is same. Informant is different. And this is investigation is still going on.
Yes,
Not-
it's going on, yes.
Not yet charge sheet.
Yes, so your lordship may kindly take into consideration the outcomes.
Niharika case is there. Isn't it?
Gist of argument, gist of
Would you like to address something on 33?
Same, my lord.
Same.
Yes.
Gist of arguments. Kindly keep it in 33. Kindly keep it in 33. This gist of arguments. Let me have a look. Okay. This, keep it in
Let's
33.
take up the item 33.
33.
The FIR, my lord.
At page
21. I have the honor to state on 10/11/23, I placed an order for purchase of building material from Ajay Bahadur Singh, proprietor of Sanitary Hardware Store, Dr. R.P. Road, Dispur, Gauhati, Assam. That in advance I deposited, only paid in the account of Ajay Bahadur Singh a sum of rupees 94,72,186 for delivery of building materials worth rupees 94,72,186, where I received material worth rupees 70,22,186 only, and the remaining materials worth rupees 25,63,720 were never delivered to me. As such, I have faced financial loss of rupees 25 lakhs and odd. Thereby the action of so-and-so is to take it. Now this is the same apparent, my lord, that there is a transaction between them. He has sought for supply of materials of rupees 94 lakhs. I have delivered certain goods which worth 70 lakhs and odd, and now financial loss to him is 25 lakhs 63,720. Now the invoices and bills I have annexed to it, and the the total amount has been, Lordship has seen, it is not 94, the transactions are, my lord, more than, my lord, 1,71,403, which have been received by them by way of, my lord, materials.
Okay.
The extra sheet I have given, Lordship, there.
In this also they have filed an objection, right?
No objection.
Affidavit.
Yes,
We file an objection.
Objection is
Has been filed.
Yes, yes.
admitted. Documents, my lord, use an aggressive denial but not specific denial, my lord. Now, this informant is the nephew of the husband of the
Yeah.
previous one. And the FI was lodged on 7/1/2024. But it was registered only on 26/2/2024, and on the next day I have been shown arrested. As per the that Bhajan last one of the ground attended which Malafati. The law, they, while I was in the custody, they ought to have been informed that there is another case pending against me. It is one factor. Rest, my lord, are same, my lord.
This is with regard to the construction of the same building? Or
No,
different-
only materials.
Only materials?
Only materials. That was an exceptional thing, my lord. Though I am not a building contractor, but she wanted my help, so I brought that contractor.
This is only for supply
It is only for supply.
from your store?
So law on this point are the same what I have already submitted.
May I add, my lord?
Yeah, sure. Yeah. Should I take up your?
My lord, may I kindly sum up?
Yeah.
My lord, the petitioner, the informant in item number 4 is belongs from Sumi tribe. The informant in this belongs from Rengma. May kindly appreciate that, my lord.
They are different tribes.
Yes, yes. So with regard to nephew being nephew doesn't arise at all. And then in the FIR, my lord, kindly come to page 12. Husband is also Sumi, my lord.
Anyway,
Kindly come to page 12 of my petition, objection, my lord, of my objection. These are the documents which I've annexed along with the FIR.
page 12, right?
Page 11, my lord. 11 and 12, they are both relevant.
Let us see this document.
Yes,
Received-
it clearly says that the petitioner, my name is reflected by Mr. Songwa Kepen, my lord. That is me. Receiving 70,22,186. Next, my lord. Receiving 24,50,000. So these are the documents furnished by the petitioner himself, my lord. So that is all, my lord.
In this case, he supplied part of the materials or
Yes,
not
yes.
part of the materials?
Now, I'm agreed.
Not the rest.
Yes, 24,50,000.
He has
What
not
material
supplied.
has not been delivered. My lord, may kindly appreciate that multiple FIR doesn't prove anything, my lord. It just shows the petitioner, my lord, the situation in which the petitioner is, which is genuine, my lord. That's why I filed the FIR. Just because he's a businessman doesn't make him immune of criminal liabilities, my lord.
Yeah, nobody. Anyway, so these two documents, sure.
Obliged.
In the invoices only, let's note one thing. These are all मतलब care of Kata ho Sumi मतलब.
Where?
At page 25.
Kata Hosubi. Informant in that other case.
And that was the identity of the accused. All goods were thrown him. As because we had a good terms, he was introduced to be nephew, so that's how all the goods were supplied.
This also like Yejo who had given the order, same order. Yejo I had dictated, same absolutely identical order, judgment reserved. Council's also same.
Oblige me.
Now the third one.
Third one, 34.
Sir.
Here, Lordship will find another. FIR at page 21. Lordship may come to page 23.
The FIR format.
FIR method. Date is dated 8/1/2023.
24.
24.
24.
Gotcha. Now at the page 24, Lordship, you can
Page 24. This is the narration. Complete.
here date is 14/3/2023.
Okay.
An FIR was lodged on 14/3/2023, came to be registered only on 8/1/2024.
Oh. Okay.
And on 11/1/2024, I have been shown arrested, therefore I was released on bail. Now, here also, the FIR, if you were to do Richard Miller, page 24, Ajay Bahadur, proprietor of so-and-so, number so-and-so, have alleged to deliver product material that is TNT so-and-so. I have made payment totaling 23,26,000 of different dates. That is 1 lakh on date 26 November 2022. It is 2,126,000 on date 29 November 2022, and rupees 1 lakh on 14/12/2022. Basically, can you see the dates, madam? And the date of the FIR, madam? That despite of the present being made, Mr. Ajay Bahadur Singh have not delivered even a single piece of TNT bar, and he kept on extending the date of delivery for the last about 3 months. Again, an amount of rupees 3,90,000 was paid for supply of tiles, which he intentionally supplied wrong quantity and wrong variety of tiles, and till that he is neglecting to correct the same. In support of this also, my lord, I have submitted these tax invoices and waybills.
In this case, the informant claims that nothing has been supplied.
Nothing had been supplied. Now these are the invoices. These are admitted, not the invoices.
Invoices of supply.
Supplied. Without e-bills, e-bills. And the very first page 25 also, TMT bar. His allegation is that TMT bars are not supplied. Page 27 are the tiles. Then page 30 are the TMT bars. Now, with regard to that, my lord, what he has said, my lord, that wrong quantity or wrong quality has been said, that dispute exists. Although he has said on 3 occasions he made 3 transactions and also submitted the supporting document, but so far as the payment of 21 lakh, that document is not available with you, perhaps.
This is also under investigation, madam? This is
Yes,
also-
yes. Sorry, Your Lordship, Niharika case and subject matter process.
The threshold is very high.
Yes, yes.
Of quashing and investigation.
Should not be judged by quashing and FIR.
It would be justified when the criteria number 1 of Bhajan Lal is fulfilled, that
Yes,
on the
madam,
face of
I
it, nothing is made out.
Yes.
If the allegations taken, accepted
Yes.
as true, do not make out an offence.
Lordship,
Then
but
it will
the
justify.
complaint itself discloses, Your Lordship.
Anyway, so
Yes.
These are the all admitted documents, these are not denied. They have filed affidavits.
objection has been filed. You have filed an objection. I'll come to you. Should I go to you?
Lordship, Lordship,
You have complete.
Lordship. If you can, I reply.
Lordship, if I may, with an objection. Lordship, in order to start, Lordship, kindly allow me to read the FIR.
Just a minute. Yeah, please. I've taken up your objection. I've taken up your.
Lordship, kindly come to page number 8 in my objection.
Yeah. In the FIR, it is claimed that no material has been received.
No, Lordship. And Lordship, in the FIR, Lordship, the agreement between the complainant and the accused, the materials was supposed to be delivered within 10 to 15 days. And Lordship, the petitioner is trying to prove that he has submitted some, he has delivered some materials by annexing some
Invoices.
invoices in the petition. Lordship, can you see the petition, the invoices? The invoices, it starts from page number
25.
25. Receive the date of invoice, it's in the top. He's trying to show that he has delivered the goods on 28 December 2022. In the top.
Yes, I've seen.
Receive the page number 26 also, 28 December 2022. It's the same date. And page number 27, the date is 10 December 2022. Page number 28 also the same date. Page 29 also the same date. 10 December 2022. And page number 30 also the same date. 10 December 2022. And page number 31 also the same date. 10 December 2022.
All invoices are of the same date.
Receipt, the first 3 invoices is released page 28 December 2022. Receipt on two dates, 28 December 2022 and 10 December 2022. Receipt, the e-fire, receipt, the e-fire was filed on 14/3/2023. After the invoice. As according to the petitioner is trying to show that he has delivered the materials on 10 December 2022 and 28 December 2022. If it so happened, the complaint of type arrest. And he's trying to show that the actress of the complainant, the actress, Question will come to page number 25. You see in the top chart, in the third column. Buyers bill do so meses dissimo si sanctum. You see the address. This is not the address which we have exchanged during our agreement.
Here also agreement is there.
No agreement.
No agreement.
Verbal agreement only.
Verbal
We have only exchanged the address for delivery of the goods. Lordship, my address in my particulars, which we have exchanged during our transaction, is correctly mentioned in the criminal petition. Lordship, we come to page number 2 in the criminal petition.
Page number
No, page number 2 in the criminal petition.
2.
Yeah, page 2.
Yes. Tell me.
Lordship, this is an address which we have exchanged during our agreement. If this, unless I furnish him with this address, and in this address, he will not implicate me as a party respondent in the present petition. This is an address which we have exchanged. However, in the e-bill, which is trying to show, completely different address, Lordship. And he have supplied the materials to me. At least he should have telephonically informed me that my goods are on the way. That was also not done by him. And that is not a condition of the petitioner in his petition, in the criminal petition. So all those e-bills which have annexed in the criminal petition, these are not genuine documents. So by this action also, it shows that from the date of the agreement, he has an intention to cheat me. That is the case. The agreement was to supply the materials within 10 to 15 days.
Okay.
So, Lordship, in order to sum up my submission, Lordship, from the action of the petitioner, as the record produced in the other case, Lordship, he is not alleged only in the, he is a businessman. He is running a business from Gauhati. And regarding his action, there are several cases pending at the state of Manipur as well as in Nagaland. Even in Nagaland also there are 2-3 cases against him. He is a habitual Hovan person. When the empire discloses materials of cognizable offense, the High Court in excess of the power under Section 42 should not embark upon an inquiry on the merit of the FIR. Just one submission I submitting that.
That's true.
That is
the
2021.
law.
It is a settled law. Lordship, no.
No. We have to learn continuously.
2021, volume 19.
2020, 2021, volume
19. ACC.
Page.
401.
Name of the case?
Niharlika Infrastructure Private Limited.
Infrastructure. It's a very important case.
I'm relying only
Others also, but this is
Para 30,
among
para
the recent
33.
cases. This is important.
Para 33.
Para 33.
33. Para 33, 33.1, 33.5, 33.8, 33.12, and 33.15. Obliged, Lordship.
Point of reply, just clarification regarding the factual part. The address in the email of the petition is the same as that of the tax invoices. Only the UA bill, because many a times the client says you deliver goods in that place. So therefore sometimes go down, sometimes up. But otherwise tax invoices, which also reflects in the invoices, are the same. And secondly, when our objection will say that these are relating to the 2022, the payment alleged to have been made by him is of the 22 only, prior to this date. So naturally, the amount what he has paid, those goods have been delivered to him. That is only two things.
But here, in this case, there is one, dispute which emerges, is that your client claims that he has delivered at least part of the materials. right?
Among the-
Some materials he has delivered.
Yes, yes.
He claims, he says that none has been delivered.
None has been delivered.
Anyway, look into it carefully.
But one he admits that some materials of not the exact description.
No, that would be, I don't know.
And relying on the this Harsad Kumar case, these are the documents. Sale transaction, commercial transaction can be relied on.
It's the same order. It's land council and this private council, respond council. Sir's name. Argument, sir. Judgment reserved. It will require some careful consideration because there are many factual aspects involved. So it may be risky to give here. So I'll read it carefully, think about it again, and then try to give a correct decision.
Yeah, this Lordship. Lordship, we prefer Lordship indulgence. Lordship, in item number 16, hearing.
Just a minute. I'll just come to you. Let us sort out. 4, 5, 6 is done. This is 9 is done. 8 is also done.
Item number 16, what the same party?
Date 27/10/25 to him.
Which one?
Item 16.
16. This is a different person.
Different person, yeah.
Different person.
Same
But
council.
similar dispute.
Yes.
Similar dispute.
Here, very interesting fact is, I have got my interim bill from here. There was a direction to appear before the court, to appear within 3 days. I appeared. They made me seek to sign an agreement. Without that, they were not ready to leave me. I had to execute the agreement saying that I will repay the amount. Thereafter, this has been challenged before the court at Gauhati.
That document.
That agreement, so-called agreement.
Civil declaration. Anyway, so yeah, you can do it another day.
Another day.
It'll be better. Let me sort out this thing.
27/10/25, and there's an interim order that can continue.
Item 16. Both the learned councils seek another date for the hearing and pray that the same may be fixed on 27 October if possible. Prayer is allowed. The interim order, filed order dated, I always prefer to write it. It's always good for reference. So order dated, we'll cross-check. If you don't remember, we'll cross-check from the record.
Lordship, interim pass earlier.
Shall continue till the next date of listing.
I'll give the date.
Date I have given 27, 20.
No, the date of the interim order.
Oh no, we'll find out from the record.
Just we have to have
You may not remember.
Just we have to have a good.
No.
For admission, item number 7.
As I was submitting before, we have complied with the court order.
You're finished?
Yes,
There?
no, it's still going on.
Oh, still going long hearing.
Lordship, this is the payment receipt, yes.
Let me just.
If this court can see the last order.
I'm just seeing the last order.
Yes.
So now compliance is done. Yes, right? So as we know, contempt is not execution, but that is one of the important factors
Exactly,
taken
exactly.
in practice.
Yes.
In practice. So heard Mr. Sophie.
Yes, Sophie.
Learned counsel for the petitioner, and Mozui.
And Mozoi.
Learned counsel for the
Respondents.
all the respondents.
All the respondents.
All the respondents. The learned counsel for the respondents has drawn my attention to the previous order dated 21/8/2025. it is reflected therein that white letter dated 13/8/2025 issued by the Director Health and Family Welfare Nagaland to the Chief Medical Officer PEG,
Principal Director.
Principal Director, yes. To the Chief Medical Officer PEG, it was informed that the Finance Department has authorized the release of back wages amounting to rupees 1,46,088 for the petitioner, in favor of the petitioner for the period 1/4/22 to 31/3/2023. The said letter has been marked as X. Today, the learned counsel for the respondent submits that after taking instructions regarding the updated status, the said payment is confirmed. Right? Said payment is confirmed, and that the order dated
0107.
1/17/2024 passed by this court in WPC 218 of 23 stand compliant. The learned counsel for the petitioner also submits that the order passed in the writ petition stand compliant. In the given facts and circumstances, I deem it fit to close this proceeding. Accordingly, the instant contempt proceeding stands closed and disposed of.
Obliged.
Right?
Obliged.
For admission, item number 8.
The Lordship, may I please, Lordship, in this petition also you have complained.
Just a minute, I have to read this. What was the order? It's good that it's been complied. This is the writ petition, I believe. It's equal scale, it was pertaining to something equal scale.
Paragraph
It was
15,
that- Yes, I'm on that one. Madam, you are representing all the respondents?
Yes, Your Lordship, all the.
All the respondents submits that in the meantime, the order dated 17/2/2025 passed by this court in WPC 153 of 2023 has been complied, and in support of the same places a document dated 25/8/2025. The order, the aforesaid order passed in the writ petition in the operative para 15 had directed the respondents to examine whether the petitioner was discharging same duties as discharged by regular grade 4 and consider his case for and take a decision on his case for being granted minimum scale of pay in that grade with a reasoned order. It transfers from the document dated 25/8/2025 that upon such consideration, the petitioner has been granted minimum scale of pay, right, madam?
Yes, Your Lordship.
He has been given the minimum
She
scale.
will be getting, since she's covered by this OM.
He would be covered by the office memorandum dated 5/3/2025 regarding such minimum scale of pay. The learned counsel for the petitioner.
Yes, Chairman.
Huh?
Yes, Chairman.
Yeah, you want to say something?
No,
It's complied.
Yes.
We can close it. Right?
Your Lordship.
I also submits that the order of this court has been complied, and the petitioner has no more grievance with regard to the same. In the given facts and circumstances, the instant contempt proceeding stands closed and disposed of. This will be kept in the record.
Yes, Your Lordship.
This order dated 25/8 shall be kept in the case.
Obliged, Your Lordship.
In terms of Jagjit Singh, that judgment,
Yes,
right?
For admission, item number 11.
This application, someone else there. Okay, it was unsolved. It came back unsolved. On the,
Yes, Your Lordship. Your Lordship, compliant to the last order dated 18/8/2025.
yeah,
However, this honorable court has given opportunity to us to determine the fresh notice, fresh address of the respondent.
Right.
However, we could not assume.
could not gather, right? Could not gather.
Yes, Your Lordship.
So it came back unsolved, huh? On this address, it could not be served. This is for the insurance company, yeah? Return to sender. Miss Meadow, your good name? Yeah. Learned counsel for the applicant. Peruse the previous order dated 18/8/2025. As reflected in the said order and also office note dated 15/7/2025. Notice upon the 8 respond number, it is only 7 respondents, I think, yeah? Upon all the respondents came back unsolved with the remark that not known, return to sender within italics or within the petition, the applicant side had undertaken to find out any different addresses, other known addresses of the respondents. In the context of the same, the learned counsel for the applicant submits that other such addresses could not be gathered. So should we go for newspaper publication? What else can be done? You can take steps again, but if the address is not there, that, yeah. This address is it's a in Nisato Colony, Kher Mahal, Dimapur. It's not a very interior, it's in the town only, I think. I don't know why it's not. Maybe people have shifted from there, maybe.
May I please, Your Lordship?
Yes, yes.
Lordship,
You are appearing from?
from Dimapur, Lordship.
Okay.
I could not come today due to some problem, Lordship.
No issues. You are appearing for?
Lordship, I'll be appearing for respondent number 127.
Oh, that's good. That solves our problem.
So, Lordship,
We were
next,
wondering what to do.
Lordship, next Monday I will file my Vakalatnama. Next Monday, Lordship, on 8th.
Learned Counsel, your good name, please, sir.
Sharif Ahmed, Lordship.
Sharif Ahmed appears from Dimapur through online mode and submits that. He has been instructed to represent respond number 127 and that he would be filing Wakalatnama on the next. So I will post it after 2 weeks or 3 weeks. Okay. So list after 2 weeks.
Deeply obliged.
For admission, item number 12.
Delay condonation
Yes, Your Lordship.
for the insurance company. Okay, 1457, sorry.
Yes, 1, 4, 5, and 7. I have already served a copy on 37/2025.
Right. Yeah, that's
And
2, 3, and 6.
yes, Your Lordship, I will also like to state that respondent number 1 is representing for 2 and 3, and respondent number 7 is representing respondent number 6.
I see.
Yes.
Minor.
Yes, 2 and 3 are the wife and children.
That is another insurance company.
6 and 7 are pro forma respondent
Pro forma respondent.
for new insurance company.
One is representing?
One is representing
2 and
for
3.
2 and 3, yes, whereas one is the wife of late Pijus Nasimudia.
Why is the wife of the deceased?
Yes, and then 2 and 3 are the father and mother
I get it.
of the deceased.
And another thing you said, who's representing 7? Respond number 7.
Respondent number 6 is represented by respondent number 7.
Nice.
Yes.
Oh, yes. They both are 7. So, service is not complete on 6 and 7?
I have already served them the copy through register post ID.
All of them?
Yes, for 1, 4, 7, yes, all of them, since they are already represented.
Okay. So, just let me see the office note service notice. There is an office note of 26A, which says, have you seen the office note? Notice to R4, return unserved, the remark, insufficient address. Notice to R1, return with the remark, addressee not found. So I think Postal Talabana, I don't know what we used to file, no, this, what is this called? Years back, I used to. It seems the service is not complete, it seems.
Yes, yes, Your Lordship.
So shall we wait, or
Yes,
you want to
Your
take
Lordship.
fresh steps? Should we wait?
We can wait, Your
We can
Lordship.
wait for some time. If it does not come, then we can think of another round of service, right? But the address, one of the reports said address is insufficient address, R4. And R1 addressee not found, insufficient. How come? Oh, I see. This is there's no address here actually. R4, it's Dimapur, Nagaland. 5, there's no address, particular address. It will be difficult to locate this. Khatkati, Karbi Anglong, Assam. 5 will be difficult to get by postal means. Anyway, so heard your good name, please.
Kim Piano.
Learned counsel for the applicant. Here was the previous order and the recent office notes dated 27/8/25 and 2/9/2025. It appears that service upon the 5 respondents and the 2 pro forma respondents not yet complete, and service report is awaited. So let us wait for some time, right? Least after we should, after 2 weeks or 3 weeks you prefer?
3 weeks.
3 weeks, least after 3 weeks. If it does not come by 3 weeks, then we can think of fresh service. And maybe 1 and 3, you can just make a note. In the office note, it was said that 1 address, insufficient address, remark was there, and 4 also. So 1 and 4, maybe you can just ascertain whether, there should be the same address. The address is here. You can just cross-check it once. Otherwise, we'll wait for 3 weeks and then decide. No problem. Least after 3 weeks.
For hearing, item numbers 13 and
hearing.
14.
It's also
Your Lordship, this matter has been kept part heard.
part heard, yes.
Yes. Your Lordship, what has happened is that in a similar
We'll just
matter,
take an introductory, this thing, and then break for lunch time is
similar
also.
matter has been disposed of. So,
Yeah, that day some submission was made.
yes.
Yes, Lordship.
Yeah,
Lordship, just to refresh your Lordship's mind.
yeah, I remember.
Yes. So, we have completed as per our stand. The state, they have taken a stand that my construction, the construction which I have executed.
Not as per specification.
Not as per specification. That is the stand. Lordship, and there is also a dispute between the state and the central that
Yeah,
the
but
project
is-
has been delinked by
Yeah.
the central government. That was the stand out. Now, my respectful submission for this honorable court is, I'm not disputing to their stand taken in the affidavit filed by the state, Lordship.
Fair enough.
But I may be made a payment which I'm entitled. If the construction is not executed as per the specification, but they did not deny the fact that I have not executed. I have already executed the contract, so I may be paid after making some assessment and verification as to how much I'm entitled.
So what, yes, disputed question of facts. So this, the Honorable Court has directed the parties to approach the appropriate forum. It's between the
one
same
important
party
aspect.
under the same project
Yes,
and same
what if I've gone through the
contractors
orders?
firm. Yes.
The difference in this case is, Lordship, there is no disputed question of facts.
Yeah.
In my case, Lordship,
No, there is disputed. We have already
I
filed.
don't
our affidavit.
dispute, Lordship.
Same.
The state may have disputed, but I agree with what their contention is to be. So if there's disputed question of fact, both the parties should take a different stand. I agree with that stand.
Read
So the
will not
question
lie.
of disputed question of facts does not arise.
When
Lordship.
there is disputed question of facts, Your Lordship, read will not lie.
Yes.
And that is the reason
Lordship,
why.
Lordship,
Yes.
I'll,
That is
make my
true.
submission.
Yes.
It is not that, as far as I know, as far as that law is concerned, It is not
Yes.
that, no disputed fact whatsoever can be touched by a writ court.
Exactly,
But
Lordship.
only to the extent,
Yes.
as I understand,
Lordship.
that those facts can be addressed by way of affidavits only.
Exactly.
If it can, if
Yes,
it can be
We have
addressed,
already put
if
our-
it can be addressed by way of affidavits,
Yes,
then perhaps the writ court may be able to resolve. But however, if it is beyond affidavit, then writ court hits a wall, dead end.
Lordship has rightly pointed out, and I'll also rely on some authorities on the same line, Lordship.
But as I understand, Lord Council, I mean, you have, part of your submission is quite fair, but as I understand, one dispute has arisen that whether you have claimed that you have undertaken the work, and the state has said that it is not as per specification. That is a factual dispute.
And I agree, Lordship.
Yeah,
I
we all agree.
Then
I agree
that's
with
it.
that.
The matter ends there, Your Lordship.
So the question of dispute
The
does not
matter can
arise.
either end there or it has to be verified. It has to be either the
Exactly,
matter
Lordship.
ends there or it has to be verified.
Yes, Lordship.
The state submission is that the matter ends there,
Your Lordship.
and he thinks that it should be verified.
Another ground, Your Lordship, it was not as per the work order, condition number 2 has been violated. No power of attorney in the name of any individual will be accepted. That clause has been violated by the petitioner. So that ground has also been taken care of in the similar case, and the matter has been disposed of.
I'll go through it.
Yes, Your Lordship. So the judgment, this judgment will squarely cover the present case. It is the same contractor's firm, the same department, under the same project, under the same scheme.
In this case, the parties have been asked to agitate
Yes, right.
before the appropriate forum,
Yes.
which forum? A civil court.
Civil form, yes.
That is the direction in the other case,
Yes.
Lordship, which has nothing to do with this case, Lordship.
No. Your Lordship, it is under the same department, as I said, under the same
So,
scheme.
so this is the submission. Should we close it?
Yes. On basis of this, it can be closed.
No. I'll close it for judgment.
No problem. Then to Your Lordship.
Lordship, if Lordship
No more
arrives-
arguments.
arrives to a conclusion in line with the case which is relied upon, if I may be allowed to submit some authorities, Lordship.
Yeah,
because-
you can.
Yes,
After you want to,
Yes,
if you want to, after lunch.
Yes, Lordship, definitely.
No problem.
Yes, Lord.
I'm open to hearing.
Yes, Lord.
I just asked whether I should close the hearing.
Another song, please.
Eleven, huh? Oh, and the Sharif Ahmed came to be continued at 2. Aware, Pugo, Kevin. Item 5 and 6 to be covered here. Who to case diary item.
And then 4 to the job for you. And then is there so we check 5 and 6 to win the GS.
Jangan be paralyzed. You can't do any procedure before that. And then you provide the case diary, whatever relevant. Yare, slow. Change duty I did to
So we'll resume this.
Your Lordship is well versed with the facts, so I want to raise the question if I may focus on number 4. Lordship, the case which was dismissed on 27/8/2025, Lordship, the respondents are relying upon to pass similar direction. If I may be allowed to, it's a short order, judgment and order, if I may be allowed to read it, to see and examine the facts and circumstances.
This order?
Yes, Lordship. This is order dated 27/8, which was passed in WBC number 337 of 23, Lord. May I read it, Lordship? If I may be allowed to read from paragraph number 2, Lordship will find it page 2. The petitioner herein has...
I'm with you.
Lordship. The petitioner herein has approached this court for release of the pending bill amounting to rupees so and so, along with the interest of 16% per annum. 3. It is the case of the petitioner that the work order dated so and so was issued to a firm in the name and style of MS Hunkam Construction for an amount of rupees so and so for development of tourist circuit at so and so in Nagaland for construction of wayside amenity at so and so legal bank. 4. It is the case of the petitioner that the work commenced on 26/6/2015 and was completed on 29/2015. It is the further case of the petitioner that the proprietor of MS Hunkam Construction had authorized the petitioner by way of a power of attorney to undertake the full responsibility of work execution. This is very important, Lordship. They have used a power of attorney in this case, Lordship. Bill receipt and payment, etc. It is the further case of the petitioner that only an amount of rupees so and so has been received and the remaining amount of rupees so and so remained pending. 8 years thereafter, on so and so, the petitioner submitted representation requesting for issuance of completion certificate and release of the bill at the earliest interest of 16% per annum. Thereupon, the petitioner issued a legal notice. However, having not received any favorable response, the petitioner has filed the present writ petition. It is seen that the respondent 1 to 4 have filed an affidavit in opposition on so and so, stating inter alia that the work order dated was awarded to MS Bunkum Construction out of the different work components sanctioned by the Ministry of Tourism, Government of India under so and so scheme. It was specifically denied that the on so and so and completed on so and so. That was denied. Commencement of work, completion of work was denied by the state in the affidavit. Whereas the stand is different in my case, Lordship. It was further mentioned that the question of permitting the petitioner to work on the basis of power of attorney did not arise, and in fact, MS so and so have violated the terms and conditions of the work order if such steps were taken by the said firm. So, power of attorney is the second question that has been raised. It was further mentioned that an amount of rupees so and so was released for partial work executed. The petitioner submitted an affidavit reply contesting the allegations in the affidavit in opposition of the respondent numbers 1 to 4. 7. From a perusal of the said stand so taken by the respective parties in the pleadings, it is important. It appears that the entitlement of the petitioner have been disputed. So that there is a dispute, Lordship. And in the opinion of this court, that such disputed questions of facts can only be adjudicated in a forum where evidence can be met. Additionally, the second ground, it is the opinion of this court that the materials or report do not suggest that the petitioner had been diligent in pursuing his remedies inasmuch as the claim of 15 is sought to be adjudicated in the year 2023. These are the two grounds. Considering the above, this court is not inclined to entertain the instant writ petition for which the instant writ petition stands dismissed. 9. Be that as it may, the petitioner herein is given the liberty to invoke appropriate remedies, if so advised before the appropriate forum, wherein evidence can be laid and the disputed questions of facts can be adjudicated subject to being permissible under law. It is observed that if a petitioner duly approaches the appropriate forum, the period during which the instant proceedings have been pending from so and so till so and so. So there was a disputed question of facts. The reason why it was referred to an appropriate forum was there was a disputed question of fact. Now, Lordship, this judgment in order was passed by my Lord Justice Barwa, Lordship. This is also important, Lordship. Now, coming to the affidavit, the second affidavit, the state have filed 3 affidavits, including an additional affidavit. The second affidavit was filed by the state respondents, Lordship. It was in compliance of an order passed by this Honorable Court on 6/6/2024.
Verification.
Yes, Lordship. Now, before coming to the affidavit, if I may be allowed to take your Lordship to page number 5, the direction of this Honorable Court.
Page number 5 of the
affidavit filed by the state respondents, which was, I have received this in the month of September 2024. The second affidavit which was filed by the state respondents. In compliance of this Honorable Court's direction, 6/6/24.
page number. Page number.
The cost title, and the page number will be page 5, Lordship.
Oh,
Lordship,
this is not the one.
yeah. In the cost title, Lordship will find that it was filed in compliance of the order dated 6/6/24. The second affidavit filed by the state respondents.
I'll find it.
Lordship.
Yeah.
Lordship, sorry.
Page
5, Lordship. Page 5. This was passed in the 2 read petitions which are interlinked. Relevant starts from page number 7, Lordship. This order was also passed by my Lord Justice Barwa. Now, 6/6/24.
Well, yeah, but I remember. Verbally informed.
Yes, Lordship. Yes, Lordship.
Verbally informed.
Now, while I'm referring to this order, Lordship, if the same question of disputed question of facts was raised at this stage, Lordship, it could have been dismissed at the threshold, Lordship, which was not done. In fact, a direction was sought, if I may allow to read it, Lordship. The third paragraph. It's a short order, if I may be allowed to read from the beginning, Lordship.
Yeah, read.
The petition and both the read petitions are the same, and the petitioners aggrieved by non-release of the remaining amounts due to the petitioner even after the petitioner have completed work. This is the observation of this Honorable Court. The respondents, however, denied the respondents have completed work. Be that as it may, it is seen from the enclosures to the affidavit so filed by the respondent that pursuant to the representation submitted by the petitioner, the respondent authorities have given a reply. In the said reply, it is seen that the said amounts have not been paid to the petitioner inasmuch as there has been no release of funds by the Ministry of Tourism, Government of India. This court, under such circumstances, this is important, had put a specific query upon Ms. S. Mary, Lyrid Senior Government Advocate, Government of Nagaland, as to whether there is any document which would show that the petitioner was duly informed prior to entering into the contracts, that the project contracts are being awarded on the basis of funding by the Government of India. The Lyrid Senior Government seeks some accommodation, let it be listed also and so.
I have remember. I have read
Now, in response to that, paragraph 3. Paragraph 3 of the affidavit, page number 2. May I read it, Lordship? That by letter dated so and so, the department has finished instruction regarding the query sought by the Honorable Court, wherein it has stated that there is no document to show that the petitioner informed prior to entering into contracts that the project contract are awarded on the basis of funding by the Government of India. They have admitted to that. However, after receiving the sanction of the Central Financial Assistance from the Ministry of Tourism, the work order was issued by government administrative approval subject to availability of central funds for the projects, which was communicated verbally at the time of issuance of work order. Since the department received only so and so, the first installment, the same was communicated verbally to all contractors. It was verbally communicated, that's what the affidavit says. So, my respectful submission at this stage is that it should not be the concern of the petitioner. It is the responsibility of either the state government or the central government to release the fund. And the central government, they have taken the stand very clearly, they have delinked, and the state should pay from the resources. Now the only question remains is when the state will pay.
I'm just going back to one basic question.
Lordship.
Just one of the basic questions.
Please,
That
Lordship.
at the time when the work order was issued,
Lordship.
right, the central funding was very much on.
Lordship.
It was on.
Lordship. Very much on, Lordship. Which is why I have received an amount of 11 lakhs rupees, Lordship.
When the second verification report was submitted,
Lordship.
saying that it is not as per the specification.
Lordship.
At that time also the central funding was on,
It
or
was
by the
already
time
linked.
it was already linked.
Lordship. It was,
Then the problem started.
There were communications made in the year 2017 as well as in the year 18, Lordship.
Process started, but it got delinked by
Lordship, Lordship. And the second verification, if your Lordship may kindly appreciate it, was only in the year 2024. They woke up from the slumber after gave more than a decade, Lordship, only after filing this writ petition. Now,
again, I'm
yes, Lord.
bothering with a query. In that, since if that is the, what would be your submission or answer to their contention?
Lordship.
That leaving aside the aspect of central funding, which is obviously a very big problem,
Lordship.
emerging in these matters, that the work executed by you,
Lordship.
is not as per specification. What can be a solution to that,
Lordship.
from your point of view?
Yes, Lordship. Even on the first day when
You may not have a...
this matter was heard, Lordship, I made my stand very clear, Lordship. I admitted, because there was in the specific, it says verification was conducted in the presence of the contractor, Lordship. I was very much there, Lordship. So I do not dispute, Lordship. In fact, the question of dispute does not arise. And in my affidavit reply, if your Lordship may kindly appreciate, I was not handed over the plan at the time of giving the work order, Lordship. There should be a specific plan, Lordship. There should be a roadmap, Lordship.
Definitely, they should be, ideally. So does that question remain disputed? I'm just trying to understand more about that issue, that point.
Yes, Lordship.
That they are saying it is not as per specification, but
Yes,
you think it is according to specification.
Lordship, I do not dispute on that. I do not dispute on that. Whatever I have constructed, Lordship, because they have enclosed even the photographs.
You should get money for that.
Exactly, Lordship. Because I was very much there on the day of verification, Lordship. And I did not dispute. Whereas this case, which was dismissed on the disputed question of facts, that's why it was referred to the appropriate forum. And disputed question of facts, Lordship knows very well. In fact, Lordship has also pointed out that if the disputed question of facts is serious, Lordship, then it can be referred to the appropriate forum. Otherwise, this honorable court has the jurisdiction to try, Lordship. I'll also rely on that. A decision of the Honorable Apex Court on the question of disputed question of facts. But before coming to that, Lordship, in a similar situated case, Lordship, this honorable court has also taken up a writ appeal, the division bench of this honorable court, where the issue of the center, they linked the project, and the sole responsibility was shifted to the state, Lordship. The division bench of this honorable court. This was passed by the Honorable Chief Justice along with my Lord Justice Manish. This is writ appeal number 17 of 2024, and this is judgment dated 30th April 2024. May I read the Lordship? This interest court appeal is filed by the state of Nagaland being agreed with the order dated so and so in so and so. The state has filed this, whereby the learned single judge has disposed of the writ petition filed on behalf of the bribe respondent, herein with the direction to the state respondent to disperse the amount of so and so to the bribe respondent within a period of 4 months from the date of the certified copy of order served upon the so and so, the director so and so. In the impugned order, the learned single judge has further observed that if the respondent 3 fails to make the payment within the stipulated time, they shall be liable to pay interest at the rate of 7.5 per annum. This is also important. From the date of default. That is the date of expiry 4 months from the date of service of the certified copy of the judgment in order. However, the learned single judge has kept it open for the state to pursue its remedies against the central government in respect of the amount which the respondent state has been directed to pay. The relevant facts of the case are that the state government had issued 5 work orders, all dated 10/4/15, to the respondent 1 construction firm to execute the construction work of the airport road, detail of which has already been mentioned in the impugned order. Pursuant to the said order, the respondent 1 executed the work within the time granted to it. However, no payment of the said work has been made to the respondent 1. Being aggrieved, the respondent 1 approached the writ court by filing the writ petition, and the writ court, after hearing the parties, has passed the impugned order. We have heard the learned counsel appearing for the parties and have also gone through the impugned judgment in order. The learned single judge has taken into consideration that the state of Nagaland has issued a work order to the respondent 1 construction firm, and it has executed the work successfully. It is also taken into consideration by the learned single judge that the state respondent...
Just pause for a moment if you don't mind. This is one bone of contention in this matter.
Yes, Lord.
That it seems that in that matter there was no dispute.
Completed successfully. Yes.
Now we have 2 barriers, as I understand. One is that dispute, whether it has been completed as per specification, and one is the funding aspect.
Lord.
Okay.
Now the funding is taken care of.
This can be one possible guidance and solution.
Lord.
And but here we are stuck with that issue. That according to them it is not as per specification.
Yes.
But
they are not disputing.
You have taken a different stance. You fairly submitted that if whatever work has been done, you may be paid for that.
Lord.
So, but nevertheless, some degree of factual dispute remains with regard to. We cannot really. There's no black and white answer to that question as to whether in this case the work has been completed successfully.
Lord.
They say it is not as per specification.
I do not deny.
So that is one challenge.
Please, Lordship. The project was linked by the central government, by the Foreign Finance Commission. So if it's agreed, then let him challenge the decision of the Foreign Finance Commission. Yes. If you want money, that will be the
money was from 14 Finance.
No, yes. So if you want further money, then he has to challenge that. Because by that
he has to be taken care by the state or central, Lordship. I'm not concerned.
Anyway, let's see what
yes, Lord.
This writ appeal has
Lordship. May I read it, Lordship, from the 3rd line, Lordship? It is also taken into consideration by the learned single judge that the state government has expressed its inability to pay the amount due to the respondent 1 for execution of the work, indicating that the construction work was allotted under a scheme of the central government, similarly situated, Lordship. However, later on, the central government, White Order dated so-and-so, has decided to stop funding all the schemes approved up to 31st of March 2014. Similar case, Lordship. The learned single judge has also taken into consideration the stand of the central government council and has opined that from the work orders issued in favor of respondent 1, it is not reflected that the same work orders were issued in pursuance to implementation of any central work scheme, and therefore the state government is liable to make payment to respondent 1 for the work which has been successfully executed by it. Learned counsel for the appellant has tried to emphasize that, as a matter of fact, the work which has been executed by respondent 1 was under the central government scheme only and not under any scheme of the state government. It is also contended that as per the central government scheme, 90% of the cost of the work is to be paid by the central government, whereas the state government is only liable to pay the remaining 10% of the cost of the work executed. It is submitted by the learned counsel for the appellant that the state government is ready to make payment of the 10% amount for which the state government is liable to, and that direction may be issued to the central government to make payment of the remaining 90% of the amount. Having heard the learned counsel appearing for the parties and after taking into consideration the overall facts and circumstances, we are of the view that since the respondent 1 construction firm has completed the execution of work in question pursuant to the work order issued by the state, and since it is not the case of either the state or the central that the work has not been executed by the respondent 1, the learned single judge has not committed any illegality in directing the state to make payment for the work executed by the respondent within the stipulated time, while granting liberty to the state government to pursue its remedies against the central government in respect of the amount which the state government has been directed to pay. In such circumstances, we do not find any case for interference. However, it is observed that if the state government moves the central government for reimbursement of the amount which has been directed to pay to the respondent, it is expected that the central government shall consider the request of the state objectively and expeditiously. The time for making payment to the respondent by the state government is extended for 3 months from today, with the condition that if the respondent fails to make payment to the respondent, number 1, as directed herein above, it shall be liable to pay interest of so. So that was the specific direction. Now, with regard to who shall pay.
In this case, there was no dispute about the completion of the work.
Yes.
So the direction to pay was upheld. However, this flexibility was given to pursue regarding the funds. Anyway.
Lordship, I'll refer only to paragraph number 22, Lordship.
In this petition, new one.
WBC 1987.
Okay.
1987 of 2022. This is judgment and order dated 5th March 2024. Only paragraph number 22, Lordship, will find at page number 14. Page number 14, if the Lordship got it. It is not understood as to how the petitioners would have been expected to complete the contract work in the year 2011, when the work orders had been issued only in the year 15. Further, the question of whether the central government had released their shares of fund for the work in question is not the concern of the petitioners. Inasmuch as the state respondent has awarded work orders to the petitioners, this is nothing in the work orders issued to the petitioners or intercontract agreements stating that the payment of the dues of the petitioners would be subject to release of funds by the central government. Nowhere has been mentioned, Lordship, even in my case. In fact, I have also filed the affidavit stating that we were not informed, except verbally, Lordship. In the view of the matter, if there is any admitted amount payable to the state respondents by the state respondents to the petitioners, the excuse that the center did not release funds to the petitioners cannot come in the way of payment of admitted liability, Lordship. No doubt, Lordship, in this case, there was an arbitration clause, Lordship. And there was serious disputed question of facts, which was referred to the arbitrator, Lordship. In our case, there's no arbitration clause, Lordship. And the dispute which the state has raised is not a serious disputed question of facts.
Tamser Ali, this is with regard to PWD.
Yes, Lordship. Yes, Lordship. It's a celebrated judgment, Lordship.
If there's an admission of liability, then of course the reed court has within its limited jurisdiction can direct, no doubt about that. Admitted liability.
Lordship.
If the liability and the amount is not admitted, then problem arises.
And Lordship, for the sake of repetition, Lordship,
Conflicting stance.
my respectful submission is, I agree with the verification conducted by the state, even till today, Lordship. I do not dispute, Lordship. Even otherwise, Lordship, with regard to disputed question of facts, Lordship, if I may be allowed to refer just a few paragraphs. 2004, 3 SSC, page number 553. 2004, 3 SSC, page 553. Even assuming, but not admitting there is disputed question of facts. This
Para.
Lordship, I'll come to paragraph number 16. The paras are 16, 19, 27, 51, 52, and 54. May I repeat, Lordship? 16, 19, 27, 51, 52, and 54, Lordship. May I start with para 16? Lord, you will find 567, page number 567.
Okay.
Lordship knows about this judgment, ABL International Lordship. A perusal of this judgment, though, shows that a writ petition involving serious, this word is very important, disputed questions of facts, which requires consideration of evidence which is not on record, Lordship, will not normally be entertained by a court in the exercise of jurisdiction under 226. This decision, again, in our opinion, does not lay down an absolute rule that in all cases involving disputed questions of fact, the parties should be relegated to a civil court. In this view of ours, we are supported by a judgment of this court in the case of so-and-so, where dealing with such a situation of disputed questions of fact in a writ petition, this court held 14. The High Court observed that they will not determine disputed questions of fact in a writ petition, but what facts were in dispute and what were admitted could only be entertained after an affidavit reply was filed by the state, which your Lordship has rightly pointed out. The High Court, however, proceeded to dismiss the petition and remind the High Court is not deprived of its jurisdiction to entertain a petition under 226 merely because in considering the petitioner's right to relief, questions of fact may fall to be determined. In a petition under 226, the High Court has jurisdiction to try issues both of fact and law. Exercise of this jurisdiction is, it is true, discretionary, but the discretion must be exercised on sound judicial principles. When the petition raises questions of fact of a complex nature, which may, for their determination, require oral evidence to be taken, this is also important, and on that account, the High Court is of the view that the dispute may not appropriately be tried in a writ petition. The High Court may decline to try a petition. Rejection of a petition in limine may normally be justified where the High Court is of the view that the petition is frivolous or because of the nature of claim may dispute sought to be agitated or that the petition against the party against whom relief is claimed is not maintainable or that the dispute raised thereby is such that it would be inappropriate to try in the jurisdiction or for analogous reasons. From the averments made in the petition filed by the appellants, it is clear that in proof of a large number of late allegations, the appellants relied upon documentary evidence, and the only matter in respect of which conflicts of facts may possibly arise related to the publication of notification under so-and-so. That is about the facts. 16. In the present case, in a judgment, the High Court was not justified in dismissing a petition on the ground that it will not determine disputed question of fact. The High Court has jurisdiction to determine questions of fact, even if they are in dispute, and the present in our judgment is a case in which, in the interest of both the parties, the High Court should have entertained. The petitioner called for an affidavit reply from the respondents and should have proceeded to try the petition instead of relegating the appellants in a separate suit. I filed my reply, I did not dispute. 19. It is therefore clear from the above enunciation of law that merely because one of the parties to the litigation raises a dispute, this is important, in regard to the facts of the case, the court entertaining such petition under 226 of the Constitution not always bound to relegate the parties to a suit. In the above case of so-and-so, this court even went to the extent of holding that in a writ petition, if the facts require, even oral evidence can be taken. It went even to that extent, Lordship. This clearly shows that in an appropriate case, the writ court has the jurisdiction to entertain a writ petition involving disputed questions of fact, and there's no absolute bar for entertaining a writ petition even if the same arises out of a contractual obligation, very much similar, involves some disputed questions of fact. Para 27, Lordship. Sorry to trouble Your Lordship.
No.
Para 27. Lordship, 572, page number 57. May I read it, Lordship? From the above discussion of ours, the following legal principles emerge as to the maintainability of a writ petition. A. In an appropriate case, a writ petition as against a state or an instrumentality of the state arising out of a contractual obligation is maintainable. Very clear. B. Merely because some disputed questions of fact arise from consideration, same cannot be a ground to refuse to entertain a writ petition in all cases as a matter of rule. 3. A writ petition involving a consequential relief of monetary claim is also maintainable. A, B, and C applies even in my case, Lordship. And this is crystal clear, Lordship. Para 51, Lordship. Lordship will find at page number 577. Para 51, Lordship. May I read, Lordship? From the terms of the contract, we have noticed in clause 6 of as amended by the addendum, consideration by way of barter of goods is not the sole mode of payment of consideration. The same so and so and so. Please, may I skip this, Lordship? 52 and 54, Lordship. 52 talks about Article 14, Lordship, and 54. Apart from the above reasons given to us to interfere with the judgment of the appellate bench of the High Court, we have one other good reason why we should not drive the appellants to a suit. The claim of the appellants was rejected by the respondent in year 94. The respondent challenged the base of rejection by way of writ in the year 96. The objection as to the maintainability of the petition was rejected by the High Court. We are now at the end of the year 2003. It took some time, Lordship. We are at this distance of time and stage of litigation to not think it proper to relegate the parties to a suit. This is also another aspect of your Lordship may kindly appreciate, Lordship. To direct the appellants to approach a civil suit at this stage would be doing injustice to the appellants. In this view of courts, we are supported by a number of decisions of this court, like in so-and-so case, where this court, though noticed the fact that the appellants had an alternate remedy for issuance of the letter of administration, it refused to dismiss the appeal on the grounds so-and-so. Now appreciating two different aspects, disputed question of facts, and Lordship at this belated stage, whether it will be doing justice to send me back to the appropriate forum, Lordship. The contract in the year 2013, and now we are in the year 2025, Lordship.
What is the date of the verification report?
Verification report, according to the state, Lordship, they have conducted verification. Lordship will find at page number 9 of the affidavit, Lordship. Affidavit which was filed in the month of April 2024.
This one.
Yes, Lordship, page number 9.
Page 9, Annexure B.
Yes, Lordship, Annexure B.
That's why I could not find the date. That's why I asked.
Yes, Lordship. But they have stated that it
Work
was conducted
order
in the year
dated 2013.
21st December 2015, Lordship.
But this verification report dated.
There's no
this
date,
was
Lordship.
because your grievance
As
started.
directed by the executive engineer, Your Lordship, the second paragraph, physical verification, there is a mention of
On
date
27
on 27th of January,
24.
yes, 2024, for joint inspection.
So apparently it was the month of January 2024. Lordship, may I also kindly perused page number 11, their photograph, Lordship.
Page number 11.
Page number 11. The photographs of the work which I have executed. It shows that they are not disputing that whether I have executed work or not. The only contention is that I have not executed as per the specification.
The initial contract, no? Does it have, madam, the initial contract or the work order, does it have any clause on these lines that the work has to be, the work, if it is not found to be as per specification?
Your Lordship, we follow this NPWD guidelines. So as per that guidelines has been violated. It was not as per the plan. And clause 2 of the terms of the and condition of the this contract has also been violated.
Power of attorney.
Power of attorney.
In regard to power of attorney, Lordship, if I may be allowed to make respectful submission.
You have submitted actually on that. Anyway.
It is only authorization. I have authorized my manager, Lordship. My manager. I did not execute that power of attorney to someone else, not an outsider, Lordship. It is my manager, Lordship, who runs the office.
Good.
Because I'm executing several projects, Lordship, I cannot oversee all the projects, so which I have entrusted by way of the authorization, Lordship.
Anything else?
Lordship.
From this side, madam, anything else?
The other day, I've already given my submissions.
Yes, you have.
Just to refresh my mind, Your Lordship. As I've said, it's a centrally sponsored scheme, 100%, and the state has no role, just an implementing agency. So here, state cannot be held liable when the project has been dealing. Your Lordship, and the central, even the central has even issued a letter in the year 2018 saying that they are making an effort to find funds for the project, which has already been coming to the conclusion or nearing completion. So that is there, but until now we have not received any intimation from the central regarding the additional funds. And Your Lordship, regarding the utilization certificate, we have already furnished it to the central. Until now, they have not replied to that. And Your Lordship, regarding belated whatever, these are just submission of the petitioner. They should be diligent enough to approach the authority on time, Your Lordship. And then, Your Lordship, without clarifying the violation of the terms and conditions, Your Lordship, I think we cannot go beyond. Go further.
That specification issue remains.
Yes, that also remains, yes. And Your Lordship has enough knowledge regarding much knowledge regarding the contract, that one of the prerequisites is completion certificate showing that work has been done satisfactorily. Here the petitioner is only relying on the verification report. So unless there is a completion certificate,
so anyway, both are same, right? Both the petitions are
Lordship.
yes,
two different bills.
Even the amount is also the same. It's just part 1 and part 3.
This will also require some deliberation, and I'll reserve this also. I'll reserve.
Just one aspect.
The full problem has arisen because the foreign commission has linked the project. So if they are agreed, let them file it.
That should not be the solution.
Theoretically, yes.
Because it is,
But practically very difficult.
The present ministry is the Ministry of Tourism, but it is the Ministry of Finance who is dealing that.
Lordship, kindly appreciate one aspect. I have invested all my resources.
The Ministry of Tourism has no.
Now the respondents cannot shy away with that kind of submission, Lordship. That is quite unreasonable, Lordship.
That is why I was again harping on this issue, that this specification issue. Otherwise, that aspect
Lordship,
is there.
And that is not disputed. Specification is not disputed, Lordship.
no, Your Lordship, that is disputed.
If I agree with it, that is not disputed, Lordship. If I object, that is disputed, Lordship.
Oh, it has to be as per what specification has been given by the authority, not as per what the petitioner would.
And I agree with that, Lordship.
That is why also I
agree with
asked a connected question that do the guidelines or whatever, the
Yes,
construction
yes.
guidelines have any stipulation with regard to that kind of situation? That suppose a contractor has made construction, but somehow there is a deviation or is not fully according to the specification.
Yes, yes.
In that case, will he be deprived of the money completely, or he will be subjected to some penalty or deduction?
Yes, Lordship.
So that is also that is actually necessary, but I don't know whether I'll have to check. So that is question came to my mind, so I asked. Anyway, let's see. That's why I'm not this also I'm not dictating here, because I'll think about it and then decide carefully. This is only for guidance. Let's see what can be done.
Is similar with the case which has been decided. So the stand taken also same. So this should apply.
I'll definitely read. I'll think about this also. And of course, it's also my duty to apply my independent mind.
Exactly,
right?
exactly.
And see what can be done about it. But it's not it is not one of those easy admitted liability matters. It has multiple facets of disputes regarding this central funding, regarding this.
Yes.
Anyway, let's see what kind of justice can be given in this matters. So I'm not learned counsel for the petitioner addresses further arguments on the matter and concludes the same. The learned government and learned counsel, sirs, submits brief reply arguments. Arguments concluded, judgment reserved. I'll try to give out these judgments, all the other three also on this, before I go day after tomorrow. And that other matter,
Yes.
kindly give me, if possible, that case diary.
Yes,
Diary. Yeah?
yes, sir.
Tomorrow also it will do.
Lordship.
For hearing, item number 17.
You can. Connected by BC?
Yes, Lordship. Lordship, am I audible?
Yes, are you audible?
Yes, Lordship, as per the instructions by Lordships on the last occasions, we had tried to contact some counsels from the State Department, and we could contact Advocate Livika, who represents state, and we were informed that somebody from the state should appear today with the instructions.
Okay. So you're
I'm for the central.
central government.
Yes, respondent number 1.
Because
This
the
petition-
main grievance is against the state taxes, right?
Yes.
So
State, yes, Lordship, state has to be represented, but in spite of service and they have failed to appear, Your Lordships. Repeatedly, it's been the matter must have been listed several times, Your Lordship, but they have been failed to appear.
True. You'd appreciate, madam, that for convenience of adjudication by the court also, their appearance and their submissions would have been helpful, right?
Yes, Your Lordship. Because
Lordship, certainly, Your Lordship.
from my
And today we were told that somebody will appear.
Somebody will appear.
I have filed my affidavit of opposition. However, Your Lordship may be aware that I have filed for deletion of respondent number 1 as a necessary party, because all the actions were initiated by the state. And there is a clear notification that any steps taken by the state tax department should be concluded by the state. So my office has no records. So I have no instructions.
You have a very limited mandate according
Yes.
to you. So you can always proceed with the hearing, but again this handicap will remain. But at the same time, you cannot keep the matter pending also, because petitioner is also agreed by something. That is why he has come before this court. Right. You also do not have any feedback about appearance? I had mentioned, I think in the previous order, they have been served, right, madam, properly?
Lordships, yes.
As per the office note, postal consignment, should items is delivered. Despite the efforts.
Chief, just one request I have, since I'm outstation counsel, I would, if the matter is being kept for final hearing, then I would like to come physically in the court and argue the matter. There are several grounds. So, then if it is kept for final hearing, date may be given.
No, it has come for final hearing only today, but you want to argue in person? You'd like to
Better that I come to the court to assist the court, as the other side is also not there, Lordship. It would be difficult online to show all the judgments and the circulars.
That is true. Some things are always better. And then in that case, we also have one more opportunity to see whether someone appears. Because since they gave you an assurance that somebody will appear, they should have.
Lordship, we were told Advocate Livika, we could speak to Advocate Livika from the State Department.
Okay.
Lordship, in the meantime,
But no one has, I can see no one is there.
Can be considered for deletion today, because I have not, my department has not.
For deletion?
Yes, deletion.
Since it is learned counsel, if you agree with me, since the matter has now reached the final stage, let's let it get concluded at this stage.
I will leave it to the
that will be better at this stage, because suppose we just for argument's sake, suppose again we need something, again it will be too late to again implead you and harassing you.
Yes.
So since you have been here,
yes,
let hold on for some more time. And anyway, madam, your good name, please.
Lordship, Aarti Agarwal.
Sivanti Agarwal, learned counsel, appears from Delhi through online mode. Mr. Chishi.
Zatkulno.
Learned counsel, appears for respond number 1. However, here is the last order dated 27/8/2025. None appears today also on behalf of the respond number
2 and 3.
2 and 3. 4, someone has appeared for 4?
No one is appearing, but 4 is a private party, Lordship, and they will, his main culprit is the respondent 4, Lordship.
Okay, no, here's my service is complete with regard to nothing, no need to write anything. None appears today on behalf of respondent number 4, as well as for the State Tax Department, represented by respondent number 2 and 3, being respondent number 2 and 3, full stop. It is submitted by the learned counsel for the petitioner that they were given to understand that perhaps the State Tax Department would be represented today. It is further submitted that considering the nature of the hearing, the learned counsel would like to address the court in person. Full stop. Accordingly, list the matter for hearing. When should I that's it's your outstation. But if you come all the way from Delhi, then
Lordship, I am based in Kolkata, Lordship.
Kolkata, sorry, Kolkata. If you are coming all the way from Kolkata also, you have to fly to Dimapur, then come here. Then, it will be, you cannot go back saying that they have not appeared.
Yes.
So that has to be.
Yes, Lordship, that is precisely the reason I did not come today. I was told that someone will appear and ask for the time to file reply. That's why.
Either we are assured that somebody has already appeared and they will be appearing, or we have to decide that we are proceeding despite their absence. Then only it will be worthwhile for madam to come.
Yes.
Right? So what do you suggest? I can fix it for hearing. That's the easy part.
Yes. Madam, a short date may be fixed to ascertain whether somebody is coming or not for a week's time, and thereafter only the matter may be posted for hearing.
Yes, Lordship, better search.
Leave the matter for after
a week.
After 2 weeks.
Oh, 2 weeks.
For appearance, if any, on behalf of respondent number 2 entry. Yes. That will be better.
Yes.
On that day, you join online and see what happens.
Yes.
Then otherwise, the law never compels you to appear in the court.
Yes.
But state respondents, they have some added responsibility. Private respondent, nobody compels you. We all know that.
Yes.
I have to be only noticed. It's my choice whether to appear in a case or not. But state respondents, especially in a revenue matter, it is not just they have to come and oppose. It's not like that also. It's they have to it helps the court what the revenue has to say.
Yes.
Even it helps the petitioner. The petitioner.
Lordship, in generally is the person who is there in the court accepts the notice on behalf of the state. Usually it happens. I've seen in my whatever limited practice.
Yeah.
The first time I am seeing that after a month or a year almost no one is coming.
Even the petitioner, needs to know what they have to say, right?
Yes.
So anyway, so this is not like some matrimonial matter where somebody is appearing expert, proceeding expert. Anyway, so that will be. Let's see what happens. We try.
Fixed date.
You can just get in touch with that council whom we had contacted and ask.
Yes, Lordship, will do certainly.
You want me to fix a date?
It will be convenient for madam.
Yes. List after 2 weeks on September 2nd, 8, 9. Can it be on 16 or 16
Yes,
or
Lordship.
18 September?
Any day will be okay.
18, 9.
18.
No?
18.
So, 2 days after 2 weeks, right? 18, 9.
Lordship.
You also try to,
Yes, I will
telling the
also
council here, just see what can be done.
try to talk with the local council.
Because I believe here there
state
is
council.
here in Kohima bench there is no standing council for tax department. I
Oh,
think the
not for
government,
not for the state.
actually we were expecting the government advocate would appear.
Yes, Your Worship.
But it seems they don't have instructions. That's a part. Anyway.
Obliged. 18th is same, Lordship.
Same matter.
Same.
Same order. Huh? It's the same order. In the end, if nothing happens, irrespective of whoever judge is there, you have to proceed. What can you do? Yes. You cannot keep it pending, indefinitely.
Yes.
We have to proceed.
Lordship, interim order may be continued meantime.
Interim order is there. So
Yes, Lordship.
the learned council points out that there is a interim order which may be allowed to be continued. Full stop. Accordingly, the interim order granted by order dated 23/9/2024 shall stand extended till the next date of listing.
Obliged.
Okay, you can log out, man. So maybe additional advocate general is here, right? Advocate general doesn't say here.
Yes, additional advocate.
Advocate. Maybe you can just, if you don't mind, you can brief him. So this is the one problem faced by the court. That revenue. The court wants to hear what the revenue says. Tax matter after all. So maybe an additional advocate general may be able to help something.
Yes, I'll talk with you.
Please do. I'll appreciate it.
Obliged, ma'am.